What's up? No, that's actually hard. Oh, okay, so then I have yours over there. Yeah, sorry. My apologies, I'm sorry. You want me to send it home to you? Just tell them it's an auto lossless case, we win everything. There you go. Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Please be seated. All persons having business with the Appellate Division. Draw near. Give your attention and you shall be heard. Please be seated.
Okay. Good afternoon, lawyers. You heard our spiel before. If you've been in this court, you have over 5.5 hours of oral argument time requested. Obviously, I cannot grant all of that time. Remember, we have read the records, we have read your briefs. We are familiar with your cases, perhaps more familiar than you will like. So when you are making when I call your case and you make your request, please take that into account, okay? First case on the calendar is People versus Berlin. What did you say?
7-2.
Yeah, remember, I got plexiglass surrounding me, so I need you to speak up. 7 and 2. Okay. Okay. I will do 5 and 2 and 5. Letao versus 1199. Tell me who you are.
Hamapore responded, 1199 SCIU National Bank.
Do we have anyone from Appellate Letao? Okay, do you wish to argue against yourself, or we actually have some good questions that you may not like, so if you want to argue, that's fine.
I'm going.
We'll give you 2 minutes.
Okay.
Okay?
Thank you, Your Honor.
H. Serenity is submitted. Chouette versus Brookford. Appellate.
I'm not sure, are we submitting or?
I'm a respondent. I'm prepared to argue for 2 minutes.
Okay.
Will you be arguing your points and I should rebut, or?
Well, usually we get to do that before you come here. So I'll tell you what, I'll give you appellant Chouette, I'll give you 4 minutes and 1 in rebuttal, and I'll give respondent 4 minutes.
Thank you, Your Honor.
Zucker versus SNY Division of Housing and Chamada Holding.
Good afternoon, petitioner requests anything to.
Petitioner Zucker. Okay.
Respondent, State of New York Division of Housing and Community Renewal, request 10, respectfully.
You folks did not hear what I had said before, right? 6, 2, and 8. Is the Tremata Holding? I guess not. Okay.
They're not appearing now.
Okay, thank you. Reef versus Nagi. Let me first hear from appellant Nagi.
Good afternoon, Your Honor. Appellant's request 82.
Cross appellant Reef.
5, Your Honor.
Okay, so I'll do 5 and 1 and 5 and 1. Vasquez versus City of New York and others.
Appellant, CCND, 5 and 1, please.
And appellant, Allsafe, LLC, 5 and 1. Respondent, RC Dolner, 4 minutes, Your Honor.
So you've abandoned your appeal, right? Your cross appeal.
I have not filed appeal.
Okay.
Respond to both of these.
Okay, I'll give you the 4 minutes. That's fine. Okay. Cobell versus Glenwood. Respondent Cobell.
Respondent request 5, please.
5 and 1 and 5. People versus Chrisgullo. The 2 cases, the 2131, the first one is submitted. People versus Chrisgullo, 3444.
Your Honor, the appeal bill is submitted.
I understand that appellant was running late, so why don't I wait till the end of the calendar and you can talk to the clerk if he shows up, okay? Okay. Okay, Lewis versus Pierce Bainbridge.
Your Honor, appellant, 7 and 3, please.
Respondent, 5 minutes, please.
Okay, appellant Lewis, you get 5 and 2. Pierce respondent gets 5. MD3 versus Selenik. MD3 appellant.
Respondent.
Let me first hear from MD3 appellant. Is the appellant in? No appellant. Do you wish to argue respondent?
Unless the panel has questions, we're happy to submit.
I think we're good. So I'll mark that submitted.
Thank you.
C. Jason. Let me hear from the appellant first.
5 and 2, please.
5 and 2, he said?
For respondent, 7 minutes, please.
Okay. Berdier versus Renaissance Midtown. Appellant Berdier. No appellant. Respondent Renaissance Midtown. What do you want to do?
3 minutes, if you have any questions, I'm happy to answer.
Do we have any questions? I think we're good. Would you like to submit?
Sure.
Okay. Okay, People versus Horton is submitted. Hashem versus Osorio. That case will be called last. Or will be heard last. So, you want to look at the time when you get to it, or you want me?
No, let's just.
Yeah,
you can
I'll
the
take the
time.
time. Let me hear from appellant.
No, 84, please. The respondent, 5 minutes, Your Honor.
Okay, so I'll let you cut that down, because I
Oh.
refused. I don't want to.
Sure.
Yeah.
Okay, I'm going to give you 5 and 2 for the appellant and 5 for the respondent. Thank you.
I will be recused in that case.
Right.
That's why I don't want to make any decisions on it. Judge Gish made that decision. Chavez versus Prana Holding is submitted. Hamapore versus Haronian.
5 and 2 for appellant, Your Honor.
5 and 2.
5 for respondent, Your Honor.
5 for respondent. NY Dangerous versus Lebrot. Appellant Dangerous. No appellant. Respondent, do you wish to submit? I know, it's hard to pull back from a fight, right? But. Well, you submitted an application on Monday afternoon. You will argue the case, and the granted yesterday is the last 24 hours of hearing. So, I'm here ready. I don't know when it's going to. Okay, tell me what you want to do. I can give you a minute, or I can mark it submitted. We have read the briefs, we have read the record, we're familiar with the case. We're ready to go on it. Obviously, not all the parties here are. Okay, so I'll give you 2 minutes. Okay. First case on the calendar is People versus Berlin. I know. I've been told that.
May I begin?
Go ahead, counsel.
Good afternoon, Your Honors. Katrina Jean Myers from the Office of the Appellate Defender for Rabu Balin. The credible evidence demonstrated that Mr. Balin's intent when he brandished his girlfriend's manicure scissors was to escape the pursuit of 2 security guards and to avoid capture by
They found some of the items that he allegedly stole on him when they arrested him, right?
That's correct, Judge, but
So why don't we have sufficient evidence to suggest that the reason he was resisting or used the scissors was resisting turning it over?
while the fact that property was recovered is an inference that may support a finding of guilt, it is not dispositive of Mr. Balin's.
But he basically admitted this. I mean, he testified at trial, right? Did he not testify at trial? I'm sorry.
Yes, Your Honor,
And
Mr.
did he
Balin
not-
testified.
He basically admitted to the robbery.
Mr. Balin admitted to stealing ice cream from a refrigerator case and unknown items from the OTC aisle. He also
The
testified
diabetic, the diabetes testing sticks, didn't?
that he stole unknown items from the OTC aisle.
Okay, so
can
he
be-
admits that he took the property. I think he said he thought he had dropped the property before leaving the store, but he admits that he did in fact have an encounter with the security officer and that he did use the scissors. So I'm not really sure how you can, how you made the statement that, you know, he's not culpable for this conduct.
Mr. Balin used force after he relinquished the stolen property. To be found guilty of robbery,
He
the
didn't
force
relinquish,
used...
he didn't relinquish all of the property, at least there is evidence that he didn't relinquish all of the property, and the jury obviously credited that.
There is also evidence in the record that his conscious objective at the time that he brandished the scissors was to avoid the pursuit of the security guards who...
What was the evidence in the record? That was his testimony, is that correct?
It was his testimony, but it was also corroborated by other evidence at trial. Specifically, the prosecution's witness testified that Mr. Balin said to him, "You have your property, leave me alone."
As he was brandishing the scissors.
There were two incidences where Mr. Balin brandished the scissors. This occurred while the security personnel were chasing Mr. Balin up Broadway. He said, "You have your property, please leave me alone."
But in fact, some of the property was still with your client, or at least there's a view of the evidence that your client, even when he said that, had property, correct?
That is correct, Your Honor.
So why couldn't the jury look at that and say, you know, he was just trying to retain what he had rather than, and that was the purpose for brandishing the scissors. Why couldn't they find that as an element of the crime?
That's an inference that could be made, but the weight of the other evidence presented at trial indicates that Mr. Balin brandished the scissors to avoid the pursuit of the security guards who chased him up Broadway, threw a trash can at him, and yelled racial epithets at him, and later called him boy at the time of his arrest. The evidence also indicates that Mr. Balin did indeed relinquish control of at least some of the merchandise. The items that he took from the OTC were not the diabetic strips that were found in the back seat of the car, so those items were unfound and were most likely discarded. Additionally, there
was property that was recovered from him, from the cab, that belonged to Rite Aid. Is that not correct?
That is correct, Your Honor.
So it doesn't really matter then whether it was the strips for diabetes or what. The property that was found in the cab that he was in was the property of Rite Aid.
That's correct. However, the Court of Appeals has found that the fact that someone may be in possession of stolen property is just one fact that may weigh in consideration of a finding of guilt for robbery, and that the intent in using force was to retain possession of that property. Here, there is
Let's be clear. That is under a circumstance where the security officer and witnesses do not actually observe the taking of the property and the relinquishing of certain property. So, I mean, it's a little different scenario than what you just mentioned in terms of the Court of Appeals ruling.
If the court reviews the surveillance footage, it cannot be determined what Mr. Balin actually took from Rite Aid, although Rite Aid merchandise was found.
Did he have it in
car.
his body?
He did not have anything on his body. The merchandise
When he came out of the Rite Aid?
He did not have anything on his body when he came out of Rite Aid. He relinquished the property. It was allegedly in his bag at the time.
So where did they find the full bottles of Febreze and the 4 ice cream bars and the diabetic test strips?
It was found jumbled in the back seat of a taxi cab, along with the possessions of his girlfriend. What items belong to Mr. Balin is unknown. And if I may address his excessive sentence point during rebuttal, that would be appreciated.
I'll give you an extra minute.
Great, thank you, Your Honor.
Okay.
Good afternoon, and may it please the court. Molly Morgan on behalf of respondent. To prove defendant's guilt of robbery in the first degree, the people had to prove that defendant stole property and that in the course of his flight therefrom, he threatened the immediate use of a dangerous instrument to prevent or overcome resistance to his retention of that stolen property.
Okay, so he took the property, he relinquished the property in that he apparently dropped the property or whatever when he was approached. The Rite Aid is on 145th and Broadway, is that correct?
That's correct, Your Honor.
So he goes all the way to, I believe, 147th, 148th Street. I mean, he's totally out of the area. He's no longer in the area of Rite Aid. So now he's relinquished the property, he's left. How is this now in the furtherance of the crime if he, in his mind, no longer has any property and these people are chasing after him?
Well, Your Honor, if defendant's self-serving testimony is to be believed, and defendant had in fact relinquished all of the property, then that could not be a robbery. But here, the weight of the credible evidence, including the fact that defendant twice brandished the scissors while still possessing the stolen property, and that when the first...
Where was the property found? Because there seemed to be a suggestion that, well, it was in the cab by his girlfriend, in close proximity to his girlfriend. So when he's brandishing the knife when he comes out of Rite Aid, does he have the property? How much of the property did he relinquish?
Well, Your Honor, first I would like to state that the evidence did demonstrate that the Febreze, the ice cream bars, and the diabetic test strip boxes were in fact in defendant's black bag, which was found in the cab close to where he was seated.
That's what I thought I had read in the record. And that's why the reason that I mentioned the specific items is because, I mean, I can see diabetic strips, weigh an ounce. I can see how they get stuck to your backpack and maybe you thought you relinquished them, but you didn't. But 4 bottles of Febreze, like, if you have them in your backpack.
Right, yeah, and those Febreze cans were made out of metal, and then there were, of course, the several bars of ice cream.
But he had other things in the backpack as well. I mean, he had his belongings, right? He had clothing and other things in there?
According to his testimony, yeah. Yes, Your Honor, but...
Well, was that discovered when he was searched, after he was arrested?
That's not specifically mentioned in the record. However, the first brandishing of the scissors, coupled with the second brandishing of the scissors and his demands that the security guards back up, coupled with the fact that this trove of stolen property was found in his bag, demonstrate that the only reasonable inference was that his intent was to overcome the security guards' resistance to his retention of that stolen property. And if I may just briefly address the sentencing point.
So he got 9 years, concurrent with 2 to 4?
That's where I was going.
Yes, that's correct.
And he was a second felony offense. He was a predicate?
That's correct, Your Honor.
And what would the minimum have been?
The minimum was 8 years, and so the 9 years that he did get was pretty close to the minimum. And in fact, the sentencing range went up to 25 years. So that sentence already demonstrates considerable leniency by the trial court. It also appropriately reflects his criminal history.
Well, he got 9 years over 4 ice creams and 4 Febreze cans, right?
Well, yes, but he attempted to stab these security guards with the scissors, and there was additional escalating
That was another
conduct.
issue, right? Because didn't one of the security guards repeatedly state that it was a knife when actually it wasn't a knife? And he seemed to describe an object larger than a pair of scissors.
Perhaps larger, but I think still consistent with a knife because it's a silver pointy object. And, defendant's actions demonstrated that he continued to escalate the situation. After he had been apprehended, he attempted to strike one of the security guards in the face, and then later at the precinct, he also attempted to strike a police officer. And these actions were, he was convicted following trial for these actions as well. The trial court
What was your recommendation?
At sentencing, in fact, the prosecutor had requested a sentence of 20 years. So I think the fact that he got
20 years for a homeless, crack-addicted defendant who basically stole food and medical supplies.
If I may just answer the question, Your Honor.
Yeah, please.
I think that request appropriately reflects his criminal history, and again was taking into account all of the actions, all of the actions, his attempt to stab the security guards and his escalating conduct throughout the day. I think it appropriately reflects that.
Okay.
Thank you.
Thank you, counsel. So why don't you address the sentencing first so you don't run out of time?
Yes, thank you, Your Honor. Mr. Balin was sentenced to 9 years incarceration for stealing diabetic strips, Febreze, and ice cream. At the time he committed this...
Counsel, is it really accurate to say that? He wasn't, if that was what this case was about, he would have gotten probably a very small sentence. This significant prison time that he's getting results from the fact that he's charged with trying to stab the security guard.
I'm sorry, Your Honor, could you please repeat your last point? I couldn't hear you.
This enhanced sentence, this significant prison term that he gets, reflects two things: his 4 previous felonies, his 37 misdemeanors, and the fact that this isn't a case about trying to steal food. It's a case about him trying to stab the security guard. That's where the time is coming from.
To address his criminal history record first, Your Honor, the legislature already factored that into the minimum sentence of 8 years, which is a considerable amount of time. Had Mr. Balin not had a criminal history record, he would have been facing a 5-year minimum sentence. So he's already serving 4 years beyond that minimum, and if the court reduces his sentence to 8, he'll serve an additional 3 years as punishment for being a criminal.
But you see, if he didn't have a criminal record,
If he didn't,
but he did, I mean, 37 misdemeanors is a lot.
Correct, and he is
Given all of the things that I said before, he's homeless, crack addict, all of that.
Not to mention the 4 felony convictions.
Yeah.
Correct, and that criminal history is demonstrative of his history of addiction, his childhood neglect. He was in special education classes and started using cocaine at age 12.
Okay, thank you.
Thank you, Your Honor.
Counsel. Thank you both. Okay, Leto versus 1199.
Good afternoon, Your Honor. May it please the court. According to Appellant, under the New York City human rights law, anyone with an excessive absence automatically has a disability, and therefore an employer is obligated.
I don't
All
think
of that is true, but
that's not what he's saying.
so that you need to have an interactive process with someone who presents, as does the plaintiff?
Sorry, Your Honor, I could not hear the last.
The problem is, let me say it as succinctly as I can. The problem is that you basically have taken or framed the issues rather than the way that the city human rights law does, namely that you are required, as late as Hoskins' decision from this court, the city human rights law has been amended to modify or change the holding in Jacobson that said that it wasn't even a cause of action if you fail to engage in that process. The state of the law now is that is a requirement. We held that in Phillips, Haskins. The law has been amended. Pimentel, at least within that time frame, has been rebuked by this court. So, like, why is it that you're not engaging in an interactive process and instead you see everything through the prism of your attendance policy? So the grievance, for example, in the grievance, the decision was, and I want to quote you the language because it's very telling. All employees must be held to the attendance policy. That is not true. All employees and those disabled employees, after they've been reasonably accommodated, after an individualized assessment of what is needed by the employee and whether those constitute an undue burden or an undue hardship on the employer, right? That's the law.
Correct, Your Honor. I wouldn't disagree with you on that. However, I do believe that we did engage in an interactive process that the appellant failed to follow through with.
How did you engage? What?
There was communications and conversations with his supervisor, with the fund's HR leadership, in terms of trying to help him take a leave of absence. And he writes back and says, I don't have anything I can go out on a disability leave with. There's nothing my doctor will sign a note for. So for us, other than asking him, are you sure, there's nothing else that could be done. We've done our...
Well, there wasn't an evaluation in the context of that process where a discussion was had about how you can accommodate it. We don't know, like in looking at the record, reading the records and reading the briefs, I still don't know, for example, what a reasonable accommodation would have been. I mean, we can't impose that. I mean, you got summary judgment, and we don't know yet, did you evaluate his request? His request was to excuse him, basically, to give him a free pass.
Your Honor,
That may not be reasonable. I agree with you.
Your Honor, but there's nothing in the record and nothing that we've seen where there was any request made other than for going out on FMLA leave.
But you have an affirmative obligation under the city law and our case law to be the one engaged in that process. In fact, even to decide undue hardship, you need to do it as an affirmative defense. So it's for you to plead and prove, right?
I understand that, Your Honor. And our view is that that doesn't extend upon a situation where there's no response back from the appellant. We try to engage him. How much further along do we have to go? Do we have to?
Well, I think you need to be clear, given all of the burdens that are placed upon you by the new law, which, by the way, 1199 supported when it was being passed. So I just want to say that on the record. I mean, the law, and I understand it can be onerous. I mean, if you read the statute and the burdens that are placed on you, I understand it. This is not, we don't decide that in this court. That's a legislative policy choice that the city council has made. And what they say is, it is your obligation to say, you made this request, that's not a reasonable accommodation request. This is the process. What about this? What about that? I know he needs to work 8 to 5 or 8 to 6, for example. It's a stressful job. Can he accept and make those calls from home? One of the things we learned during the pandemic is that a lot can be done from home. So was that even discussed?
Well,
you have the obligation to initiate.
There's 2 points I'd like to address. I think evaluating a reasonable accommodation claim that arose in 2016 and 2017 under the auspices of COVID.
I got that.
The other point I'd like to address is that I think the Lazari versus New York City Department of Parks and Recreation is really instructive here, because in that case, which was dismissed on summary judgment, affirmed by the Second Circuit, it involved a situation where an individual who had similar kinds of medical conditions, and a claim brought under the New York City human rights law, similar kinds of interactions where it was just conversations with his fellow employees or his supervisors or human resources.
The problem that you have with that is that the Second Circuit is not binding on us, and the Appellate Division First Department have been charting a totally new course that's consistent with the legislative policy choice that the City Council made.
I understand that, Your Honor.
That's the problem that you have.
To me, the facts of it are so analogous, it's hard to distinguish between that case and this case.
I got it.
Thank you
so much. Well, good job.
Thank you, Your Honor.
You got it. Schwetz versus Brookford.
Hello, Your Honors. Thank you for having me. This case essentially boils down to this court's interpretation of RPL 234 as it interrelates to my client's lease. We are, in this instance, seeking the legal fees that came about due to 15 years of litigation coming up and through administrative agencies.
My question is, I mean, I read your record, I read your briefs. I mean, you present a very sympathetic case. The problem is that the owner never commenced a summary proceeding against you, right? Also, the owner did not allege that you had defaulted on this case, right? So, or that you violated any rent laws. So the only issue is whether DHCR properly denied the owner's OPD, right? Despite the fact that the plaintiff's household income was, at least in 2004 and 2005, never exceeded the 175,000 threshold, right?
Exactly, and the primary argument that we're making here is that, first of all, RPL 234 doesn't require necessarily a summary proceeding. There has been lots of cases.
Well, this court has said that it requires an action, right?
It does.
A DHCR proceeding is not an action.
A DHCR proceeding, in this terms, is an action, and it was an action specifically seeking to cancel a rent-stabilized lease, to terminate
What
a
case
rent-stabilized lease.
what authority do you have for that proposition?
Well, as far as it being an action or proceeding, we mainly say.
I mean, we have held that DHCR proceedings are not action, nor a summary proceeding, an administrative proceeding, right? So.
Well, in this instance, under Marsh v. 300 West, the RPL 234 is not about just a summary proceeding. It is about reciprocity of the language and the attorney's fees provision that existed within this lease under paragraph 16 and 17 explicitly say any kind of action, proceeding, or otherwise. You know, it is written in such a broad way because this is the old 1955's language prior to the enactment of RPL 234.
But we have read that language differently, right?
Exactly. You have read that language, and you know that it does say or otherwise. It intends to be very.
So are you asking us to reverse our pretty robust authority that this provision does not include administrative proceedings, and I think as recently as 2015, maybe that's not so recent, but in 2015, in matter of 251 CPW House, we said that there is no reciprocal right under RPL 234 for fees in administrative hearing.
And I do understand the court's position, and I don't think you need to overturn yourself in this instance because of the language of this lease. I believe that it's not about interpretation of RPL 234 here.
So what is
it is about the interpretation of the language of the lease.
What's the specific language under the lease which would lead us to that conclusion?
Well, the specific language under the lease, as referenced in my papers here, would come down to, sorry, I don't have it memorized, unfortunately. There's quite a bit in those two paragraphs, but it would come down to paragraph 16 and 17. And essentially the terms otherwise, and it also, you know, talks about any action proceeding and or otherwise.
So you think that in the case of any such default, reentry, expiration, or dispossess by summary proceeding or otherwise, you think that the otherwise may include an administrative proceeding, but.
Exactly, because they're explicitly looking to terminate and do a lease termination via the rent stabilization laws, stating that they have acted, that they're not allowed to maintain their rent stabilized lease under terms that can be read into the lease under the case of, I believe it is Marsh.
Okay.
Yes.
I just want to ask, now, paragraph 17 of the lease talks about when the landlord incurs fees by reason of the tenant failing to comply with the lease provisions. Is that correct?
Exactly. And in this instance, the landlord is saying that the tenant no longer has a right to a rent-stabilized lease. In other words, hasn't held to the lease provision because she's over the income threshold and thus is trying to deny the lease. So the fact that she has breached this implied lease covenant, if we turned it around the other way, would mean that she would get the application of this law.
Okay, thank you, counsel. Let's hear from Mr. Turco.
May it please the court, Jeffrey Turkel for the respondent. This is not a rent-stabilized apartment. It's a rent-controlled apartment. There hasn't been a lease since 1955. We weren't trying to terminate a lease. And as I established in my brief, even if we had prevailed in the DHCR proceeding, we would have been obligated to offer the tenant a lease. There was no dispossess here. I'd like to limit my remarks, unless the court has any questions, to the issue of whether tenant's appeal is frivolous. Justice Acosta, you said that the tenant presents a sympathetic mien to the court. I don't disagree, but there are limits. When this case was commenced in March of 2019, I contacted opposing counsel, whom I know and whom I like. And I said, this case is frivolous. Please, don't. Let's withdraw it. Counsel declined. I then wrote a letter pursuant to Rule 130.1. And the letter, which was single-spaced, 3 pages, was basically a mini version of my brief. I cited all the cases that Justice Gitch decided as robustly contrary to the tenant's position. I explained that the lease provision that the tenant was relying on didn't apply. Nevertheless, counsel declined to withdraw. We moved to, and I said in my letter that we would move for sanctions.
But you realize that, you agree that just with respect to the issue of frivolousness, I mean, you agree that the otherwise language is different or can be interpreted as including something other than an action.
No, I don't concede that. It's seeking to dispossess the tenant or re-enter the premises in a summary proceeding or otherwise. It always goes back to dispossessing the tenant or re-entering the premises. So I do not credit, as Supreme Court did not credit.
So you can, okay. So you can actually bankrupt the tenant by having them incur $150,000 worth of fees and just not starting a dispossess, but going through a DHCR process, right?
Your Honor, the law is the law. If the legislature wanted to protect tenants in that circumstance, it could have said Article 78 proceedings. Instead, it said actions and special proceedings. We don't have that. The tenant's relief is found in Albany. It's not found in this court. As I said, I wrote the letter.
But part of the standard for sanctions is that the arguments that are proffered cannot be supported by a reasonable argument for an extension, modification, or reversal of existing law. You think it was frivolous for them to come in and say, look at this again because of the consequences of decontrolling an apartment? You think it was that clear-cut that it was frivolous? They couldn't argue for reversal here?
Well, I would respectfully submit that it was frivolous because the issue is not the, I'm sorry.
No, go ahead.
The issue is not the consequences to the tenant. The issue is not whether the tenant can afford this, okay? The tenant's income in 2004 and 2005 was well over $200,000.
That's for the legislature to consider.
Right, exactly, okay? All I can say is that, as you said, Justice Gitch, there is very robust language that neither a DHCR proceeding nor any appeals therefrom, nor an Article 78 proceeding falls within 234. The tenant's lease argument, I think, is extraordinarily strained. And in
I find it interesting that you're commenting them for quote unquote being frivolous, and you proceeded with 8 proceedings against the plaintiff. I mean,
Your Honor,
8 proceedings against them?
That's not accurate, Your Honor.
It wasn't 8?
It wasn't 8. The case went up to the appellate division. There was an Article 78, went up to the appellate division. DHCR moved for remand saying we screwed up, we messed up, send it back. So then there was a second DHCR proceeding and a second Article 78 and a second appellate division proceeding. This court granted leave to go to the Court of Appeals. This court obviously did not believe this was frivolous. The Court of Appeals heard the case on briefing and argument, even though it originally wanted to do it on a sua sponte, letter brief proceeding. We lost 6-1. Judge Garcia said we should have won. There's nothing frivolous about what we did, and if it was frivolous, then the tenant is in essence saying that this court is part of the malicious behavior because it granted leave to go to the Court of Appeals. This court obviously didn't have to do that.
You're kidding, right? You don't really mean that.
I think that's what...
It's all right. It's a little glib, but I'll accept what you have to say. But
well,
honestly,
when he says it was frivolous for us to go to the Court of Appeals, how did we get there? It wasn't an appeal as of right. I think that's the implication of what the tenant is saying. I think that during this time of COVID and limited judicial resources, the tenant was warned by Supreme Court that her case was lacking in legal merit. The tenant was warned in my letter. This shouldn't have been here. We shouldn't be wasting everybody's time.
We got it, Mr. Turcotte.
Thank you, sir.
Yeah, thank you. Okay, we'll give you a minute, counsel.
Does the court have any further questions
You know,
for
the
me?
context of the otherwise in paragraph 16 really doesn't contemplate what you're suggesting. It talks about default, reentry, expiration. When you look at the other words in the sentence, otherwise just couldn't be stretched to mean what you're suggesting.
Well, I feel that at the time, in the 1950s, they were essentially trying to write as broad of a language as possible, and the actual term should be interpreted as broadly as possible as the drafter of that document would have intended to cover and protect his client. As to the specific language, I feel that it is not merely that one sentence, but the entirety of the two paragraphs taken together that give rise to
We've
our
looked
specific
at very
language. Yes.
similar leases. And I mean, one thing that I would say that Mr. Turcow is correct is that there is a legislative policy choice to be exercised here.
Yes.
And tenants have their own lobbyists, but not in this court.
I do understand that, and I feel that it is a matter of justice that my client receive appropriate remuneration for 15 years of what we perceive to be harassment.
I appreciate it. Thank you both. Zucker versus SNY Division of Housing and Community Renewal.
Good afternoon. May it please the court, I am Eugene Nathanson. I represent appellants Susan Zucker and Janice DeYoung. There are three irrefutable components of petitioner's argument. The first is when an owner seeks to eliminate a required service and its only justification is to increase its profit, the application has to be denied. The second is that the record here doesn't show that it was impossible to continue the required service, and in fact shows the opposite. The third is that the owner shouldn't be able to piggyback on its illegal action in going ahead with the construction on the roof before it applied for permission and now say because it did that, it's impossible to take it back. As to the first, I think it's worth looking at.
So where does the modification of services come in? I mean, obviously, at one point DHCR was all in line with your position, but then they sort of, and maybe it's different arms of the same agency, but then they turn a different way and they say, well, we're going to allow the modification of services. How does that work with their last word on this subject is that there can be this modification of services. I'll grant you that they don't give you a particularly great award for that at the $50 a month, but that's their last word on this subject, isn't it?
Well, I actually didn't hear every word of what Your Honor said, but I think that the concept you're addressing is this was an elimination of service. This wasn't a modification. The owner came in and said, we want to get a modification. DHCR
But then DHCR allows the modification.
Well, they didn't. They recognized that it was a total elimination of the service. In any case, DHCR did allow the elimination of the service, did so only on the owner's say-so that it was impossible to give the service back. And I mean, I think that's...
So isn't a test whether what DHCR said, is it irrational or not?
Yes, and it was irrational for DHCR to simply accede to the owner's statement that we can't return the service. The owner
How would they
didn't...
have been able to return the service when I thought the construction had already been completed on the roof with the two penthouses?
Your Honor, there's no evidence in the record that construction had been completed. There's no evidence in the record as to the state of construction at all. So for all we know, the construction hadn't been completed. There was still space available despite the construction. For all we know on the record, even after the construction, there's remaining space on the roof. We don't know an owner didn't prove anything. What we do know...
I'm sorry. Would any space on the roof that was used to restore the garden and the space on the roof comply, or did it have to be the exact space?
Oh, it wouldn't have to be the exact space. It could be something substantially equivalent or, nearly equivalent or something like that. Absolutely. It could have been.
So, in your view of the law, if they had restored the space in accordance with the original order,
Yes.
right, then the limits on the rent that were in the original order would have been, they could have gotten them lifted. I think they would have had to ask the agency, but it would have been restored at least prospectively, correct?
Absolutely. That's exactly.
Right, and let me follow through.
Okay.
And could they then have otherwise applied to eliminate the service prospectively?
So had they restored the service, could they then later apply to eliminate the service?
Right.
Well, yes, they could certainly make the application, but as I said in the beginning, it would.
All right, so now really it's like, what is the difference now in terms of the authority of the DHCR to allow a prospective elimination of the service?
Oh, because that ultimate application, had they followed the procedure Your Honor suggests, would have simply been the owner saying, the tenants have a service, I want to take it away from the tenants. The only reason I want to take it away from the tenants is so that I can amass even more profits. No other reason. No building necessity, no change in condition, no other issue other than I'm going to take the service away, I'm going to sell it to some other entity, and I'm going to make millions of dollars from doing that.
But isn't that a question? I mean, you're not suggesting that landowners should not have the power to deal with their property, right? In that fashion. What you're saying is we need to be compensated. And then the question becomes, what is an adequate compensation?
No, I disagree, Your Honor. I say that they're allowed to use their own property to the extent that it's not protected by the rent laws. For example, the owner could not move an internal wall, take over square footage of a rent-stabilized tenant apartment to give it to the adjoining non-stabilized apartment, so it could increase that rent. It can't do that at all. It can do a condo conversion if it wants, but it's not allowed to take away the service, which is protected under the rent laws. So that's exactly what it can't do. Okay, so, and as I said, it simply was not impossible to give it back. The tenants explained in their papers to DHCR that the roof space had been shared with penthouse terraces prior to the conversion. So I think, actually, I welcome any other questions from the court, but I think I want to just emphasize the fundamental point. And I did want to say, at the very least, that the respondents didn't respond to any of these arguments, even here. They didn't explain why it was impossible. They raised a totally side point on Rent Code 2522, which petitioners did not mention, but it's in no way the basis of petitioners' argument.
Okay. Thank you, Councilman.
Good afternoon. May it please the court. I'm Robert M. Barris. I'm of counsel to Mark F. Palomino, who's the counsel for the respondent, New York State Division of Housing and Community Renewal.
So Council, why couldn't the roof space be given back to the tenants, space which they have for over 30 years, and was basically appropriated by the landlord for profit?
Your Honor, it's our position that the rent administrator's determination, as affirmed by the commissioner on the par, that it was that the roof space had already been allocated to the condominium purchasers in the offering plan, and that
there was at least one space, right? One of the condos was being sold for $21 million plus, right? So I can't imagine that that condo would have been as valuable without the roof space that it was allocated to it after being taken from the tenants, right?
Correct,
Can you have
obviously.
that a shared space, for example?
I
mean, I know that you're entitled to a lot of deference from us, but not a rubber stamp, right? I mean, it has to make sense. And then when you have a condo that takes over that space and is now valued at $20-something million, and then the tenants are given $50 a month as a rent reduction. I mean, I was like, wow. So if you can explain, I would appreciate it.
Your Honor, I'm not in a position to explain anything of that determination beyond what's in the record. I can't speculate as to what was in the rent administrator's mind or the commissioner's mind beyond the words that were put into their determination.
So we don't know whether construction had already begun on that space or had not begun on that space, or that there was no basis or no ability to return that space to the petitioners?
The record is not clear on that point.
Is there anything in the record that would indicate what the value was to the tenants of the original order, which reduced the rent from to the rent that was in place prior to the last increase and didn't allow further increases? What was the value of that would have remained in place until they restored?
Well, obviously, Your Honor, that would be different for each tenant depending on what that tenant's legal regulated rent was, and there is nothing in the record as presently constituted that would evidence those amounts.
Well, you had the landlord who kept referring to that argument as de minimis, right, under the rent stabilization law. That is the use of the roof space.
Pardon,
right?
Your Honor?
So, I mean, de minimis, maybe that's why they got the $50 a month. You agree with the landlord that it was de minimis?
No, that was, the agency ruled against the landlord on that argument. The landlord's par was dismissed as untimely. It didn't file an Article 78. So the proposition, the finding that the roof access was a required service and not de minimis is res judicata as the.
No, I understand that, but see, the problem is that once you characterize something as de minimis, you would think that something that will raise the value of a condo over millions of dollars will be worth more than, I mean, I consider $50 de minimis in this context. I mean, that's even less than Starbucks money.
Your Honor, I can't supply the court with anything beyond what the rent administrator put in his determination.
See, and that's what we try to determine, because usually we give you a lot of deference. But to me, without getting at those issues, it's almost like rubber stamping all of the decisions that have been made administratively, which is something that I detest.
Your Honor, I'm limited by the record as it's presently constituted.
Okay.
So what did they base the decision on? I mean, I'm not understanding. Was it simply the landlord coming in and saying, we can't return the space, and so therefore, that's it?
Pardon, Your Honor?
What was the determination based upon? What evidence or what information was it based upon then?
It would have to have been based, Your Honor, on the fact that the condominium offering plan had already been filed with the Attorney General.
Yeah, but they're amended on the reg.
Right. Yeah, that's I don't understand. That's not something that that could not have been amended. Something that could not have been changed. So that would have been it.
Do we know if there was a contract of sale on that apartment? I mean, that might be a limiting condition. But if there is no contract of sale, then the offering plan can be amended.
The record doesn't explicitly speak to what the facts were as to the process of sale of the 3 condominium units on the roof.
Does the record reflect the size of the roof space that the tenant had before this began?
Pardon, Your Honor?
Does the record reflect the size of the roof space?
No, there are no precise numbers in the record as to the size of the roof space that was previously accessible to the tenants. I believe there is information to the record as to the size of the roof space that was allocated to the 3 condominium units.
And what's the size of that space?
Pardon?
What is the size of that space?
My recollection, thousands of square feet, Your Honor.
Yeah.
Does the record also reflect that the respondent owner was the purchaser of the condos, right?
No, The respondent here, the respondent Tremata, was the entity that purchased the 14 remaining rent-stabilized apartments from the condominium developer. So the Tremata is not the entity that owned the condominium units. It owned the rent-stabilized. It owned those condominium units that were occupied by non-purchasing rent-stabilized tenants, including the two appellants here.
Thank you.
Thank you, Your Honor.
I'd just like to clarify on that last point that it's clear from the record that Tremata purchased the building after the original DHCR decision, ruling that the roof was a service that could not be eliminated and ordering that it be given back. So Tremata was a knowing purchaser, and of course I have the argument in the brief as to one, the preservation, and two, their obligation based on the previous owner. And if there are no further questions.
No, I have a question. Could the purchaser of those 14 apartments have affected a restoration of the property on the roof?
Well, that's an interesting question. I do not know what the terms of the purchase agreement are. I don't know to what extent Tremata protected itself against the risk. I mean, being aware that tenants objected to the taking away of the roof and aware that DHCR had already ruled that that was improper and that DHCR had ordered, I would hope that Tremata got some protections from the owner, from the developer when it purchased the apartment.
Assume for a minute that he didn't. I'm not saying that's right or wrong. Then doesn't that play into the impossibility argument? I mean, wouldn't that be a basis for the DHCR to say, it's impossible to restore because the entity that is otherwise the owner of these units has no rights in the condominium to otherwise do that, to compel that restoration of services?
Well, the answer is it may have been technically impossible, but that's a result that can't be allowed, because if that result was allowed, then in this kind of transaction or in any transaction, a party could divest itself of responsibility for its acts, its rightful or wrongful acts, by passing it on to a new entity and saying, well, I wash my hands of it, and the new entity can wash its hands of it.
There was a remedy, and I know we're maybe skeptical of how good that remedy was, but there was a permanent diminution in rent. Permanent, right? That's a remedy.
But I think following the structure of the rent regulations, the proper remedy is simply to continue in effect the original rent restoration order until at some point, perhaps, somehow the service can be restored. I mean, one other possibility, by the way, reflecting on that impossibility, is somehow the new landlord could find some way to provide to the tenants some equivalent service. Maybe not the roof, but something that the tenants might even agree to as an equivalent service. I mean, interestingly, in this case...
They made some attempt to provide an alternative service, but the point is that it's inadequate in your view.
Well, certainly that courtyard was, as explained by the respondents. It's interesting that, I mean, by petitioners, it's interesting that Tremata or the owner originally said, we're giving them all of these things, all of these amenities, et cetera, and then took away 90% of them and left them with just the courtyard. I mean, again, the landlord does have things that it might be able to do that might make up for the difference.
Okay, thank you. Thank you both. Reef versus Nagi. It's not right. It's not right.
Good afternoon, Your Honors. May it please the Court. William Sharon from Prior Cashman for the appellants. Statutory interest is a time value of money award that is used to make an injured plaintiff whole for the lost use of a sum of money. It doesn't exist to make a plaintiff more than whole. It's not a windfall, and it's not a punishment. It's simply compensation because a plaintiff did not have a sum of money available for some period of time. That's why CPLR 5001 and 02 require a sum awarded, quote unquote, for there to be an assessment of interest. The sum awarded is the damages, and that needs to be determined in some way. And in this case, an inquest was directed to determine whether damages exist. And as this court said in the Paulson case, which we cited, quote, an order granting summary judgment as to liability and directing an inquest as to damages is not a determination that plaintiff is entitled to damages. They need to be proved. Because I don't have a lot of time, I'd like to jump right to something that is put in the respondent's reply brief. They used their cross-appeal reply brief to really surreply our appeal. And they, for the very first time in 2 years, cite to a Court of Appeals case from 1959 called Michalowski. They never cited it before, and the Supreme Court did not rely upon it in its decision. And the reason is because it's inapt. But they rely heavily now, and so I'd like to take 2 minutes to address it. What Michalowski says is it talks about the 3 scenarios where you would have replevin damages that need to be...
So wasn't there a replevin here? Wasn't there a claim for replevin? The replevin, they wanted the art back, right?
That's correct, Your Honor.
And they got the art back.
They
did
got
they
the art...
not? And so under Michalowski, isn't there a formula for damages under those circumstances?
3
that
formulas.
actually is somewhat akin to your idea of the lost value of the use of the property.
Right, 3 formulas come out of Michalowski.
Right.
2 of them don't apply, 1 does.
Okay.
One is if you have merchandise that is, quote, useful only for sale or consumption, meaning what they say is grain or livestock. Now, that doesn't apply.
Well, that's not the only thing, right? Art is saleable, isn't it?
It is saleable, but it's
Okay.
not usable only for sale or consumption. And here, if you look at their opposition brief at page 29, I'm going to quote it. They actually make the point. They say the heirs were under no compulsion to sell the artworks in the past, nor are they under any legal duty to
Does
sell.
Michalowski say that you have to be under a compulsion to sell?
It says only, Your Honor. It says usable only for sale or consumption. So that is absolutely not applicable here, which is why Supreme Court doesn't, it's not cited anywhere. The other method is...
Well, you will allow, if it's only an issue of law, that I suppose we can look at it and there are no further facts.
That's why we moved, this was actually a joint motion under 4401 because it's a pure issue of law. All the facts are stipulated. The other method in Michalowski that's discussed, which is, as Your Honor already alluded to, it's merchandise for sale that depreciates in value. If I steal this pen from Your Honor and it's merchandise that Your Honor sells...
Wait. That's a secondary argument, a formula there. This hasn't depreciated. Nobody said it's appreciated. The art apparently
it appreciated by $900,000.
Right, it appreciated. But I'm looking at the Michalowski case right now, and I'm sorry, I don't see the word only for sale.
So it's...
No, you know what? I'm looking at it now. Okay, if the article was merchandise kept for sale, grain, and all other articles of property useful only for sale or consumption. I take it back.
That's right, Your Honor.
Okay.
And so depreciation, the other prong doesn't apply because the art appreciated. And that leaves us with lost usable value. That's what this inquest was supposed to be about. Michalowski says that replevin damages are about a full indemnity and no more. And so here, they were required to prove some lost usage value, and they specifically averred they had none. What they say at their surreply at page 15 is that the Supreme Court reasoned that but for my client's interference with their property rights in the art, the heirs would have recovered $2.5 million. That would have been so if they'd elected conversion damages, but they wouldn't have gotten $2.5 million plus replevin of the artworks themselves. They elected the art, as Your Honor noted. The art rose by $900,000 in value, which is more than damages plus interest. Damages plus interest was only $575,000, and that's why they got their full indemnity. They are entitled to no more. Thank you.
Thank you.
May it please the court, Raymond J. Dowd of Dunnington. Before I commence, I'd like to ask if the panel has any questions.
Oh,
Yeah,
we will.
I do have questions. I'm gonna go back on that Michalowski. Is it true you just raised it for the first time in reply, right?
That's a case that we put in there, yes.
Okay, and is it your contention that the damages for the period by which you, I guess, made a demand for the return of the property until the time that it was otherwise returned or effectively available for your use as possession, that is what controls the calculation of damages
It's
slash interest?
well, we rely on Fantas Foods, which says the ordinary measure of damages for conversion is the value of the property at the time and place of conversion plus interest.
Well, is a replevin also a conversion?
Well, we never got it back, and that's what the Supreme Court correctly ruled, is that...
Well, you did effectively get it back at some point.
No, Your Honor.
I know you're shaking your head. No, let me finish. At some point, you effectively got it back in terms of that it was sitting with Christie's. You didn't really have it back then because there were stays in place and you couldn't direct what to do with the property. But at some point, the stays that were in place failed, evaporated, because the defendant never put up the bond. And after that time, which I think was in November of 2018, then you had all rights of ownership, even though it wasn't physically with you, it was still with Christie's. What's wrong with that?
Absolutely not true.
All right, tell me why.
The underlying tort of conversion is to make a wrongful claim of title. We got a ruling from the Supreme Court saying that there was a bad faith...
I thought conversion concerned possession. You'll excuse me.
No.
You know, I thought that conversion is, regardless of title, you have a superior right of possession, and I take it in derogation of your rights. I possess it. It's possession, or I can, to your detriment. It had nothing to do with title per se.
That's one aspect of the Seventh Regiment test of the Court of Appeals. It's either you take possession, which is asportation, or you wrongfully assert to the owner a claim of title. Those are two different things, and there's a third option not applicable here. But that wrongful claim of title is the conversion. So here we have the possession with Christie's, a wrongful bad faith claim of title being made, which, as we know, an auctioneer in New York cannot auction artworks if there's an adverse claim of title because of the warranty of title that one is required to give if there's an auction. So the bad faith continuing claims of title continue through final judgment and through today. We do not have, as the Supreme Court correctly found, use of the chattel because we can't hold a free auction of it. And saying that, well, if you escrow the proceeds of the auction and I'll hold on to that, that's not the type of credit. And Justice Borak found correctly. If you pay your rent and don't dispute it, all kinds of things where we look at where you would get a credit for giving a chattel back. They haven't given it back. They've kept the claim of title, and they've stymied us in our ability. It's not like saying, well, you can have these artworks back, I'll let you sell them, and if there's some damages claimed, nothing like that. Is it still a claim of title that was made in bad faith that continues through today?
So Mr. Dowd, what evidence did you present with respect to the deprivation of the economic value of the artwork with respect to these continuing claims of ownership? How did that constitute?
Well, through November 4th, 2018, the adversary obtained a stay on a sale of the goods. So
no, I understand, but I'm saying, what evidence did you present to show the deprivation of economic value of the artwork? What was the evidence that you
Well, they literally had, at one point, his total possession of it, which satisfies the claim for conversion. We just didn't have access to it. So a deprivation of possession, you look at the value of the property possessed as if, you know, you had my stocks and bonds, or as if you had my car, or as if you had these things. It's like you loan people money. So $2.5 million worth of art that they had for a certain period of time.
But then you got it back, though.
We still don't have it back. We don't have it free and clear. And that's exactly what the Supreme Court found in determining the question of fact.
2.5 million as of November 13, 2015.
Correct, Your Honor. And we still don't have the artworks back free and clear. We cannot sell them. And that is the reason we have been deprived of the use of ownership, as the Supreme Court correctly found.
Thank you, Counsel. Okay, you get 1
Very
minute
briefly.
each.
Thank you, Your Honors. Your Honor is correct. Conversion is about possession. My friend Mr. Dowd is mistaken when he said conversion is the wrongful claim of title. My standing here arguing today is not an act of conversion. The cases that we've both cited are about asportation, about intermeddling in the most decisive manner with armed men and taking possession of property.
Well, let me ask you something more fundamental than that. Did they get the property back?
They did get the property.
When?
So they got the property in June of 2018. It was delivered to Christie's as their agent at their instruction.
But they couldn't sell it. You went and you ran and got stays conditioned on filing bonds. Bonds weren't filed. So literally from June, at least through November, there was this prohibition against them doing anything in terms of exercising a right of ownership.
No dispute, Your Honor. We have based our argument on November 2018, not June 2018, for that reason, because the stay that this court had briefly entered, we agree is like the vigilant.
Okay, so one other question. So what about since that time? Is there any restriction on them acting as owners of this?
That's the thing. He keeps saying we can't warrant free and clear title. They got that. That was the remedy they got. They got a declaratory judgment of title, and that award is not stayed. Just because they want to go to the market in a particular way is irrelevant to this court. Your Honor, Justice Friedman's decision in Thompson v. Andy Warhol Foundation, which has been often cited for this very principle, that the art market is its own entity. It's not about the law. There's Mayor Gallery v. Agnes Martin case from 2019, quote, "It is not for the court to determine what the art market should or should not credit as reliable." They have possession. They have title. They have not shown any evidence, Your Honor. There was no sum awarded, and because there was no sum awarded, there was no basis under the CPLR to award interest.
Thank you, Counsel.
Thank you.
So you have title.
No, Your Honor.
Why not?
Because he argues and continues to argue today and will argue, as he said to the Court of Appeals, that we do not have title. So what we have is cloud over a title.
I didn't hear him say that at all.
He didn't say it, but his papers do. And he said
You have a judgment that says that you own this artwork.
Yes, and we have an appeal where he is continuing to assert title.
You're up at the Court of Appeals?
Sorry?
You're up at the Court of Appeals?
No, he went to the Court of Appeals and got bounced back down, and he continues to assert title. He has not withdrawn.
There's a declaratory judgment that's under appeal? I'm confused.
That's correct.
Okay.
And he continues to cast the cloud of title. And with the cloud of title not clear, we have no ability to sell this artwork. It's in prison. And if we look at the language of the CPLR, and Justice Bora correctly found, until you say you can have this back and do what you want with it, the case law shows you don't get a credit towards prejudgment interest. And they keep asserting title to the artworks. We can't do anything with them. That's why prejudgment interest is appropriate for every single day through final judgment.
Thank you. Thank you both.
Thank you.
Vasquez versus City of New York, Dolner et al.
Good afternoon. My name is Evie Kazansky. I represent the City of New York and CCMD, which is also known as the Koch Theater. This is, involves a summary judgment motion that denied I'm just going to call them CCMD's motion to dismiss the Labor Law 200 and common law cause of action, and also we sought common law indemnification and contractual indemnification against
So the problem here is, that there's a flaw, that the tiles were removed, that wasn't straight, you build a platform on it, and plaintiff gets injured when he rolls his ankle on that. Who's responsible for that flaw?
The argument that CCMD made was that it's not a hybrid situation for 200 and common law. It's basically, the judge and everybody also already agrees it's a means and method, there's no supervisory control. But then she also said that it could be a hybrid situation where there's a defective condition on the property. In this particular case, you can distinguish a defective defect as opposed to the means and methods. And we argued it's only means and methods because the area where the accident occurred was an active construction site, closed off to the public, to other people. There was tools there. There were things there that CCMD did not control.
Is there anything in the record as to how long the floor condition was in place? How long it was?
Yes, the floor was removed a while before. There's no doubt. That's the whole reason why that area was set up in that way. The floor was being removed to put in new floor and steps. So before they could put in the permanent steps, they removed the flooring, meaning the contractors, not CCMD. They then put up a platform so that the carpenters and drywall, such as the plaintiff, could do their work and fix the walls. So that area that was...
And who was responsible for removing?
The contractors.
Be more specific. Dolner?
That's part of the issue. They're not named in the case. So the only contractor...
But is Dolner...
Dolner, yes, is our chief.
Contesting that it was his responsibility, not All Safe's responsibility?
That's the issue.
To smooth that uneven ground?
That's the issue with the platform. So there's two issues going on here. There's the platform situation and the temporary floor, the flooring that was removed that left what you see in the photographs, the arguably
So
gray.
is it
So
your
the
argument,
problem is you're dealing with two...
argument that this is not a premises liability situation?
Yes, we're saying that it should
Because
only
was
have been
a
reviewed...
fenced off or a separated construction site, it was actually part of the construction job? Is that what you're saying?
Yes, it's distinguishable from other cases, especially the one, DePaul, where he was walking over rotted planks across...
Is your argument, I think it's 4 months, that floor was in that condition for 4 months. Is your argument adversely affected by the fact that the condition of the floor had been in existence for 4 months?
No, because the area where the situation occurred was closed off to do work on the walls.
I thought that the area, that the work was to install drywalls and also some acoustical renovation.
Yes, over the steps that were eventually going to be put in. If you've ever been to the...
Close off, just so that we're clear, the closing off was at least for the entire 4-month period that the floor had been torn up?
Yes, the security guard says that area is normally locked, and they need, the construction people need a key to get in, so the door is normally left open for them so that she doesn't have to keep giving them the key. It was not an area open to the public. Part of Koch was open to the public. This was the area where the steps were going to be redone, and the acoustical and the walls around it. And even the plaintiff himself would tell the security guards and other people from CCMD not to go into that area. His chop saw was there. So the argument is,
Let me ask you this. Suppose we didn't agree with what you are now saying, and we looked upon it as that it is a premises situation. So does Dolner owe you indemnification in that case?
Dolner's contract is a negligence trigger. I have to concede that. That's how it's written. However, it says Dolner and its subcontractors. It's clear CCMD did not do that work. Their contractors left that condition in that way, plus plaintiff's employer also.
So then you would argue that it's Dolner's responsibility.
Someone else's negligence.
That it's Dolner's responsibility. If it was CCMD's responsibility, then that responsibility transfers to Dolner.
The contract makes it clear that during the time of construction, that area would have been under Dolner's to clean, to take care of, and do whatever needed to be done pursuant to the scope of the work. And it also, that indemnification clause is not limited to just Dolner. It also includes their subcontractors. CCMD clearly did not create that condition.
Would Dolner be indemnifying you for your own negligence then?
We are entitled to part.
As the owner, as the lessee, you had a responsibility to see that that floor, if it's a premises question, you had a responsibility to see that the floor was in good condition.
Well, the first issue is we argue that we don't have.
Would you be permitted to get indemnification there, in light of the fact, are they indemnifying you for your own negligence?
At this time, no, but it's a construction contract, so we would be entitled to partial indemnification. At the very least, we're entitled to then conditional indemnification, and that portion of our quote-unquote arguably possible negligence would just be deducted from the indemnification that they would owe us for the rest of the case.
Thank you.
Thank you.
May it please the court, Robert Ely, Melito and Adelson for the appellant Allsafe. Allsafe was a subcontractor at this work site. R.C. Dolner was the general contractor. Allsafe had a very limited scope of work to install a platform. The platform, just so we get the facts exactly correct, the platform was not installed over a floor. The platform was installed over a staircase. There was a floor leading to the staircase, which is what the plaintiff ended up, that was uneven.
Was there any indication, or at least some theory of liability, that you as the builder of the platform should have put a step onto that uneven floor that he fell on when he stepped off the platform?
No, and the court already ruled, specific to that there is no responsibility, there is no duty. So there were claims brought against Allsafe for labor law violations as well as common law negligence. The Supreme Court correctly ruled in favor of Allsafe and dismissed all those claims. So there are no claims against Allsafe in this case anymore. There's been no appeal from that, and therefore,
I guess,
that's the answer.
I am confused, I'm being imprecise in my questioning. You know, I guess one of the issues in terms of Allsafe is the indemnification issue and the arising out of, and that, to me, we allow for the fact that arising out of can be different than actual negligence, right?
Yes, that is correct, except in this case, there's really two things that are involved. One is Allsafe did not employ the plaintiff. So that whole aspect of it is out, is not involved here, it does not apply. Allsafe was a subcontractor for the prime contractor, which was responsible for the floor itself, adjacent to the platform.
Okay.
And the plaintiff testified, and everyone else testified, that the platform did not falter in any way. And that is why the court dismissed all the claims against Allsafe. Now, in terms of the contractual indemnification, the only thing that the court left, which I believe is error, and is the reason for this appeal, is that
the court dismissed all of Dolner's claims against you is because it's between Dolner and Allsafe. There's no question that the liability for the floor would fall upon Dolner.
That is correct. So yes, the only cross claim, the only claim that is remaining that the court left is the contractual indemnification claim by R.C. Dolner against Allsafe. That is the only one that exists currently
And you're
against
saying
Allsafe.
you should have been granted summary judgment on that?
And that is it. And the reason for that is basically the Brown versus 2 exchange
Yeah, no, we're good.
and all the other case law that have cited in this. Thank you.
Good afternoon, Your Honors. Adam Greenberg, law office of Harrington, Occo Monk, for defendant, respondent R.C. Dolner. And as you heard, R.C. Dolner has 2 contracts that are here at issue today. The first being with the owners, which is CCMD. Now, they're claiming a right to indemnification as against R.C. Dolner.
But you agree with respect to your contract with Allsave, you saying Allsave is not, it is your responsibility, basically. That's why you're not contesting Supreme Court's finding.
Well, what I am contesting is the following. If you want me to, I was going to get to CCMD first.
That's fine.
Okay.
I didn't mean to alter your...
No worries. But with regard to CCMD, the contract with the owners, the indemnification provision in that one requires a finding of negligence. And to date, there's been no finding of negligence by the court. And the fact remains that there were a lot of witnesses who testified that this condition on which he fell, this allegedly uneven floor, was typical.
It's true it speaks of negligence, but clearly CCMD turned this site over to you, right? I mean, you're the general. CCMD wasn't doing any work there. They weren't supervising anyone there.
That is correct.
So it's between CCMD and Dolner, if there's responsibility for that floor, doesn't that responsibility properly fall on Dolner?
Well, yeah, I don't think we're contesting that as a general contractor, they had certain duties with regard to maintaining the premises, and we're not contesting that. But the indemnification clause, the CCMD requires a finding of negligence. And so my only point is that until there's a finding of negligence, they are not entitled to indemnification. The other point, which is corollary to that, is that there is an ample basis to find that CCMD, as the owners, did have a duty, as an owner does, to maintain the premises. And if there is a condition which they're claiming existed for approximately 4 months, an owner does have a right of the property, and they had an opportunity to inspect and observe the conditions. And
But what's your response to the argument that this area was not available to the public in general, that it was part of a construction site, notwithstanding its condition for 4 months? It was still part of the construction of that area.
well, just because it's part of the construction site doesn't mean that the owners have no responsibility towards it. The owners have a common law responsibility towards the premises. They also have, and this goes to the Labor Law 200 issue.
But isn't it part of the work site itself? I mean, isn't this the work site?
Sure, but it's part of the premises, and which...
Well, work site is always part of the premises. How
Correct.
could it otherwise not be?
Correct.
But
and
not every means and methods case is also a hybrid notice, dangerous condition case.
Exactly. And my point is this, is that with regard to the Labor Law 200 claim, they're claiming this is a condition of means and methods. But we're forgetting that the condition on which he fell was a floor. And it's our position that a floor is a condition of the premises. And as a result, supervision and control is not required, because a floor, unlike a ladder or a scaffold, is something that all the contractors have to walk upon. So we believe this is a condition of the premises, and so Labor Law 200 would be applicable against the owners only upon proof of notice of the condition, and supervision and control is not required. So we do believe there's questions of fact as to their negligence under Labor Law 200, as well as the fact that the indemnification provision requires a finding of negligence. And that's with regard to CCMD. With regard to Allsafe, we acknowledge that there was a finding that they weren't negligent. However, the courts have drawn a distinction between negligence and arising out of. And in numerous cases, the courts have held time and time again that you don't need a finding of negligence to establish a claim.
We understand that, but what was it about this particular circumstance or set of facts that you could come under a rising out of?
Okay.
What is it about what they did that the accident on the floor arose out of their building a platform?
I'd just like to cite some language from a case of this court called Hunter Roberts Construction Group. And what the court said was, generally, the absence of negligence by itself is insufficient to establish an accident did not arise out of an insurer's operations.
We agree.
Rather, if I may, rather, the focus of an arising out of clause is not on the precise cause of the accident, but on the general nature of the operation in the course of which the injury was sustained. And in this case, the general operation, as the court below pointed out, is that this man was on a platform. Now, according to Allsafe's testimony, it was only 8 inches off the ground. According to photos and the affidavit of the plaintiff's expert, it was 16 inches off the ground. And not only that, but according to Allsafe, it was built on a tiled floor, whereas the plaintiff's expert says it was built over a dirt floor. And based upon the fact that this involved more complicated situation than walking on just stairs, but being at a platform 16 inches above, the entire operation included the platform.
Okay. Thank you, counsel. Okay, you get 1 minute.
I was fascinated. I'm sorry. Very.
Imagine how we feel.
Just very briefly, with respect, I think the court has it correct about what was going on in this situation. We've cited plenty of cases where as Judge Gish said, the construction site is always part of the premises. So we cite to ample case law that merely because it's a floor does not necessarily mean it's a floor that is a defective inherent in the property. It's part of and parcel of the area that they were working in. And therefore, if we're not...
It's part of the work to be done. It's part of the work to be done.
Thank you, Judge Friedman, yes. And therefore, if we're not negligent, then we could at least be entitled to common law indemnification because, as I said, I do concede that the contract does say negligence triggers of donor and or its subcontractor. And I would just say that also Lopez, which is what the lower court cited too, also is very instructive about a hybrid situation, and that's where somebody fell on through a temporary floor. And they said that just because the owner had a general knowledge of what was going on with the construction site, you wouldn't necessarily think that that area was dangerous, and no complaints. Donor even themselves testified that they didn't think the area was dangerous, so why would CCMD go into an active construction site with tools and other things going on and suggest it? So I would respectfully say Lopez is the most instructive in terms of a hybrid. Thank you.
Thank you. Okay, 1 minute.
Very briefly, I just want to make sure that we're not relitigating facts here at the Appellate Division that were already decided by the Supreme Court and there's no appeal. Thank you.
Okay. Thank you all. Okay. Cobell?
Good afternoon, Your Honors. May it please the Court. Catherine Beer from Morrow Lilling Naparty for the defendant's appellants. The tree well border in this case that plaintiff claims to have tripped over was not decayed, it was not cracked, it was not damaged in any way. It was wholly intact, and to use plaintiff's own words, it was in good condition and it was well maintained. It was also serving its intended purpose. It was containing a tree and soil that was lining the curb of 65th Street. The plaintiff here admitted that she was familiar with the area. She had been in the area every other month in the 8 years at least leading up to the accident. She knew that the tree well border was there, even though she claimed to not have seen it on the night of the accident. And she admitted that on the night of the accident, she saw a tree. Therefore, even if she hadn't been familiar with the area, common sense would lead one to assume that a tree is enclosed by a tree well border. The plaintiff also testified that there was nobody to her right that would have prevented her from using the sidewalk to walk. And in fact, a friend of hers had traversed the area and avoided the tree well altogether without incident.
But her expert said that the tree well border was inherently dangerous. Is that correct?
He did in a completely conclusory fashion. He didn't cite any violations that the tree well border that it violated any standards, that it was that it was inconsistent with what is usually done in the industry.
What
It was-
about the tree, something about the guards, the New York City regulations or something as to the New York City Department of Parks? Tree guards be 18 inches in height?
Those are recommendations, they're not requirements, and as plaintiff's expert put in his report, the purpose of them being 18 inches is to protect the flowers and the trees within the tree well. It's not to prevent pedestrians from falling over them. And that's another point that we raised in our brief, that this was located near the curb. It wasn't in the middle of the sidewalk. It didn't pop out of nowhere.
But plaintiff did testify that it was low to the ground and very hard to see.
She testified that, and it's our contention that it was completely open and obvious. She had passed by the occasion many times in the past, never had an issue before, never considered it dangerous.
So sounds like two good arguments before the jury as to what it was, right?
It's not, because as a matter of law, when you look at the picture, there's no way to say that this was an inherently dangerous object. It's something that you expect to be there. We walk on the streets of New York every day. We expect...
Didn't she also claim that there was snow? I mean, wasn't it the whole, the issue was that the accumulation of snow also prevented her from actually seeing the inherently dangerous condition?
So the snow, at best, is a red herring, because our expert, using meteorological data, provided that on the day of the accident, the amount of snow that fell throughout the entire day was just a little over half an inch. It was 0.6 inches. The tree well border at its lowest point...
But she didn't claim that she tripped because of the icy condition, right?
No, she did not claim that she tripped because of snow and ice. If she did, then it's our contention that the storm in progress doctrine would prevent her from succeeding. But the fact that it snowed 0.6 inches on the date of the accident, the lowest point of the tree well was 1.5 inches. The highest point was 4.5 inches. So even if...
There's nothing really to conclude from that, because we all know that the wind pushes snow around. You know, I think that the record certainly creates an issue of fact about whether snow was obscuring this tree well.
I don't think so, Your Honor, because she didn't say that the snow was completely obscuring it. She said there was some snow on it. She didn't claim that she couldn't see it at all because of the snow.
So then we get back to the tree well itself. Let's just look at the tree well. And do we have a standard by which we can figure out, or a standard that the construction of this tree well deviated from, such that it was a dangerous condition?
Plaintiff's expert never provided any such standard in opposition to our motion. He didn't give any requirements as to how high the tree well had to be. He didn't say it was in violation of any requirements or statutes, or even that it wasn't proper within the course of the field. He simply provided a conclusory opinion that this was inherently dangerous.
Okay. Thank you.
Thank you.
Good afternoon, may it please the court. Lisa Comeau for the plaintiff respondent. I'd like to just point out, before I get to any of the other points, the testimony from the city witness is very important here. It's true that our expert did not point to a per se administrative code regulation, something of that nature. However, the city witness testified that they would never, that number one, the city certainly would never have installed this border around the tree because it's considered a tripping hazard by the city. And I also want to point out in my brief, at page 1230.
That's not an industry-wide standard either.
No, it's just that the reasons, when you put that together, you have to consider the human factors, which the plaintiff's expert addressed in detail in the affidavit. The city witness testified that the reason the city doesn't put a raised border is because it's a tripping hazard. That's exactly what happened here. She tripped on the corner, and I will address the reasons why I think that happened and why it's inherently dangerous. But the city requires all of these tree wells that have borders to be flush, or the other alternative is the 18-inch high iron grating or gate that protects the tree. So when you are...
I know you say that. Is that in a regulation or a rule that's in the record that you pointed to?
Well, we're not saying that they had to have an 18-inch high, but the testimony of the witness at page 1234 to 1235 and also on 1236, John Muller raised tree borders are recognized by the City of New York as a tripping hazard. That's why they neither install them nor allow them to be installed. Now, when the defendants or their predecessor decided they wanted to put in this decorative border, they were supposed to get approval from the city. There's no evidence that they ever got that approval. The only thing that's in the record is like some sort of a notation that also references something being flush. Clearly, this is not flush. And the
But
city
the record,
witness...
the record also reflects that the city did not install it, right?
No, we're not saying that. So when the owner is deciding that they want a decorative border, what would the jury consider when the issue of that negligence is before them? Is it foreseeable that...
I'm sorry, I know I'm interrupting you. Is there any evidence in the record that these were built in violation of getting a permit? In other words, were there any violations for these
It's not, there are issues of fact about that because it's not entirely clear from the record when this was installed and who installed it, but there is discussion in the witness testimony about
Well, isn't that a
city...
matter of public record? Don't you go back to the buildings department records, isn't that available to you? Didn't you have to put it forward to create an issue of fact?
Well,
at least your expert had to make a search, see what's going on here?
I don't know that it's something that would even be filed with the building department, but the point is, Your Honor...
But didn't the superintendent testify that the tree beds or whatever were installed or constructed at the same time as the building was constructed, which is about 15 or so years prior?
I believe it was from the paperwork, it's around 2006. It's not entirely clear. But the point is that they installed it. The city never would have approved it. And even though we're not saying that that's necessarily an administrative code regulation or a statute or something like that. However, a reasonable jury could conclude for the same reasons that the city considers it a tripping hazard. And what are those? This thing is raised 1.5 inches and it slopes up to 4 inches. There's a tree, it extends around the tree. At the time of the accident, it was covered with snow. The snow doesn't have to be 4 inches deep.
Even you say, you never really make the snow an issue here. It can't be unsafe because it's snowing and then safe when it's not snowing.
No, it's harder
to... It's either inherently dangerous or it's not.
It's inherently dangerous and it's harder to see when it's covered with snow. You don't need 4 inches of snow.
But the snow is irrelevant to whether it's inherently dangerous, isn't it?
But something that's part of the foreseeability, when you're installing something like this in a public sidewalk where people have to walk under all conditions.
Your argument is, and I'm sorry for interrupting you, is that it's inherently dangerous because if it snows, you can't see it?
It's inherently dangerous for a number of reasons, including the fact that this is no different, Your Honor, than a raised sidewalk flag of 1.5 inches because it's where people walk. She caught her foot on the corner.
People don't walk in tree wells. I don't think that's true, honestly. People don't walk in tree wells. In fact, even under the sidewalk law, the city knows that they're only putting responsibility on the abutting landowners for the sidewalk and not the tree wells because they know people they don't walk in tree wells. They're not supposed to.
That's true, but she didn't trip in the tree well. She tripped on the decorative trim that's 6 feet long. It's much larger than the tree. From a visual point of view, you see a tree. Does that mean you know that there is a raised border, and which is not routinely used throughout the city of New York, as the city witness testimony establishes? And also, she had never been there in the dark before. I know counsel pointed out that she's passed this way other times over previous months. However, she had only ever been there in the daytime and not when it was snowing. And she's not saying that she slipped on snow. Yes, that's true. But even a light dusting of snow can obscure the fact that there is a decorative border where you wouldn't necessarily expect there to be one. So our position, Your Honor, is that these are good questions, but they're good questions for a jury. It's not a simple question of law. It's a question of fact that should be determined by a jury at trial.
Thank you, counsel.
Thank you.
Very briefly, Your Honors, the city witness's opinion is not indicative of a standard that needed to be followed here. His opinion that the city wouldn't have approved this particular tree well border is irrelevant, basically, because it doesn't establish that the plaintiff raised a question of fact with respect to how high this tree well border needed to be.
If they shown that the city does not install them because it's a tripping hazard, why isn't it an issue of fact? I mean, What kind of expertise do you need to bring in to create that triable issue?
Because my adversary brought up human factors. I think it's common sense that you don't walk where a tree soil or a tree well
But
is.
obviously she didn't know that there was a tree well there. She didn't know that there was a tripping hazard, otherwise she wouldn't have tripped.
Right, she wasn't reasonably utilizing her senses. She wasn't walking like a reasonable
But she
pedestrian.
was, especially if that area is somewhat opaque by the snow or affected, or visibility of that area is affected by the snow. It could be that the snow was blown into that obstruction that's only a few inches off, right?
And in that case, then I would argue that it makes no sense for her to avoid the complete empty sidewalk to her right and walk in an area where snow had blown. In that case, and there's no evidence.
No, but she can walk in the entirety of the sidewalk. She just didn't know that that obstruction was there, and the city is saying there's a reason why we don't want it there, because it's a tripping hazard.
There was one city official's opinion. I don't know that that necessarily establishes.
That's good closing argument, right?
I don't think so, Your Honor. I think just looking at the picture, looking at this tree well, is very clear that this is not an inherently dangerous object.
Now, the
15
pictures
years.
were not great, guys. Sorry.
I'm sorry?
The pictures were not great in this record. They
The
were
pictures
terrible.
could have been
I
better.
don't think looking at the pictures is dispositive here.
You could barely see anything in the picture.
I agree. Some of the pictures were not the best pictures, not the best
Thank you.
quality.
That's why we like it to be in color, so that we can at least see.
These
But,
were in
hey,
color, and they were still.
we don't create the record, you do.
Just very briefly, I just want to point out that as the superintendent testified to, there had been no accidents, no complaints about this tree well border in 15 years leading up to the accident,
Okay.
which is certainly.
Well, you only need one, right?
Thank you, Your Honors.
Thank you. Ay. People versus Chrisgullo. Okay.
Good afternoon. May it please the court. My name is Marty Tankleff. I apologize for wearing jeans today, Your Honor, but I just was notified that I was making the oral arguments at 1 o'clock today. And that's because lead counsel in this case, Stephen Metcalf, is quarantining in his home state of Maryland because of his potential exposure to COVID. However, I have agreed to move forward because our client has been in prison for a number of years when he was not constitutionally convicted. He was deprived of the effective assistance of counsel, there was a Brady violation, and during the post-conviction process, we would submit that there was some disingenuous actions by the district attorney's office when they used grand jury subpoenas to seek to obtain information that they sought to obtain through HIPAA releases. And the information contained in those letters mirrors exactly what was contained in the grand jury subpoenas. One of the biggest issues in this case is a Brady violation. Under People v. Wallet from this court, it was a sex case where 2 days after the defendant pled guilty, there was a notice of claim that was filed. In this case, there was a notice of claim that was filed, and it wasn't discovered until after Mr. Chrisgullo had pled guilty. Had he been aware that there was a pending civil lawsuit against him, I don't think he would have rushed to plead guilty. And I think any attorney who was aware of that probably would have advised him completely differently because there was a rush to take this plea bargain. And as the body of evidence that we've presented in the lower court establishes, the Judge Lieb should have granted an evidentiary hearing based on the fact that we developed computer experts, forensic experts, and the lower court denied Mr. Chrisgullo no hearing whatsoever. And we are asking this court to remand the matter for an evidentiary hearing.
An evidentiary hearing as to what, counsel?
To allow the
Are
experts.
you talking about his 440?
Yes.
Okay, so his 440 was made 2 years after the plea?
Yes.
Okay, and the basis of his 440 was what?
There was ineffective assistance of counsel.
And the basis for the ineffective assistance of counsel was because the council allegedly did not investigate your client's allegations that this whole incident flowed from the fact that he was having some type of relationship with the mother of the 10-year-old victim, as opposed to the 10-year-old victim who stated that he raped her. Is that correct?
That was just one of the issues. There were a number of issues.
What was
that
the other issue in terms of ineffective assistance to counsel?
failed to consult with expert witnesses,
Expert witnesses as to?
computer experts to establish I think they call them the e-drives or the electronic communications.
So there were numerous emails, text messages between he and the child, setting up liaisons, dates, etc. There was numerous evidence against the defendant where he made certain statements on Valentine's Day, I think, in the classroom. So with all of this, given all of this, again, what would be the basis for the need for an evidentiary hearing pursuant to his 440?
To allow the experts to testify that they would have challenged the accuracy of some of that evidence. And without those experts, the defendant was deprived of constitutionally effective assistance of counsel.
You would challenge the Gmail and N-grade?
The N-grade especially, because I believe his name was Mr. Workman, said that a lot of it could not be accurate.
Okay.
Thank you.
Thank you, Counselor.
Good afternoon. May it please the court. Cynthia Carlson for the Office of Darcel D. Clark. The defendant's conviction for the first-degree rape of his 10-year-old student should be affirmed. The record below, including the plea minutes, the sentencing minutes, and all of the evidence before the 440 court, overwhelmingly established that the defendant was competent when he was being prosecuted, that he pled guilty voluntarily.
So he was sentenced to 14 years incarceration, is that correct?
That is correct.
What was the max?
The max was an aggregate sentence of 50 to life because he was charged with 2 separate A2 felonies. And again, just to respond to some comments that counsel had made, the evidence before the 440 court established that these claims were outright fabrications by the defendant. He is heard in his phone calls discussing the civil suit and trying to hide his assets from the civil suit before he even pleads guilty. In addition, the use of a grand jury subpoena was proper because it was done pursuant to a separate grand jury investigation, which was detailed to Justice Lieb, and with all of the information before her, she properly denied the motion without a hearing. If there are no further questions for the court, the people will rest on our brief.
Thank you.
Thank you.
Go ahead, Counselor. You got 1 minute.
Thank you. The only issue I would address is the subpoenas, because what we find disingenuous and very odd is that the exact information that the District Attorney's Office sought on December 20th, 2016, and I believe it's December 21st, 2016, mirror exactly what they requested in a grand jury subpoena to the Nassau County Jail and to the Suffolk County Jail when we believe there was no grand jury sitting at that time. And just because the information that was obtained was some of his phone records, we submit that this court should remand for an evidentiary hearing. And the way the methods that the district attorneys have used to obtain some of this information, we question was improper.
But I thought all of this information was put before the court, and that at some point in time, I thought that there had been a firewall that had been set up as well by the district attorney's office.
There was a firewall established. However, at that time, we had not seen the grand jury subpoenas. It was our client who actually got the grand jury subpoenas. So we were making some arguments based on kind of some basic information we knew, but we never knew the contents of the grand jury subpoenas until after the litigation ended.
But this was, the result of this was the telephone calls that he made from the facility, is that correct?
Correct.
But there are signs, I believe, in the facilities that clearly state that any communications that you engage in are not confidential, and that you're being recorded, and that they may in fact be used against you.
So when these phone calls were being recorded, it was Nassau County Jail, and if I remember correctly, there was some actual litigation that took place because some of the signage was not posted and some people were not notified that all of their calls were being recorded. And as we argued in the lower court, we don't believe that the Chinese wall or the wall that was set up.
I don't think we call it Chinese wall anymore, with all due respect.
Okay.
But anyhow, the firewall, whatever that was set up, again, this was based upon the recordings, and he apparently knew what was going on and that his calls were being recorded.
But that's just one of the issues that we raised in the lower court, and in addition to the ineffective assistance and the Brady violations, and this is why we believe remand for an evidentiary hearing is appropriate.
Thank you, Counsel. Lewis?
May it please the court, my name is Neil Brickman, and I represent the appellant plaintiff, Don Lewis, on this appeal. This is an appeal from the trial court's improvident granting of the Putney defendant's pre-answer motion to dismiss. Interestingly, there does not seem to be a dispute or disagreement regarding the law detailing the pleading requirements of each of the necessary to sustain each of the three causes of action. Rather, respondents' arguments on this appeal and the court's purported justification for its dismissal order seem to rest entirely upon characterizations and findings related to some of the factual allegations contained in the complaint. And therein lies the pervasive error that we are imploring this court to correct. This was a pre-answer motion to dismiss. As this court is well aware, all of the factual allegations of the complaint should be accepted as true, and Mr. Lewis should have been afforded the benefit of every possible favorable inference. Instead, Your Honors, here the lower court completely ignored certain of the pleaded allegations of fact contained in the complaint, and as to others, made determinations like they were unbelievable, incredible, woefully insufficient.
Yeah, but that wasn't the only reason, right? Like, for example, the court talked about privity with Yim and Putney, right?
Well, that's exactly right, Your Honor. And therein, again, both the lower court and the respondents acknowledge that a third party like Lewis, who is not in privity, may maintain a claim for malpractice, that it is not shielded by immunity or public policy if the attorney's acts constitute fraud, collusion.
Right, but just calling or characterizing conduct that is otherwise within the realm of an attorney's responsibility while doing an investigation, that doesn't make it fraud because you say it's fraud, right?
Well, Your Honor,
the court has to make some evaluation.
Right. Your Honor, therein lies the crux of the error. Because what the court ignores completely, it says, just because you call it fraud, collusion, malicious, or tortious acts, doesn't make it so. What makes it so, Your Honor, are, if you look at the initial brief, pages 6 through 8, our initial brief, there are items A through M of factual allegations that specifically call into question whether this investigation was a sham investigation.
Well, just because he didn't agree with the way the investigation was proceeding, the procedure of it, that's not an allegation of fraud or collusion.
Your Honor, exactly correct. And that is not what those allegations are. I call your attention specifically to item number
What specifically was the fraud or the collusion?
Collusion is that the Putney defendants offered plaintiffs the right to author the findings of this investigation if he would agree to withdraw from the firm and a permanent gag order not to continue to complain about the financial improprieties that caused the investigation in the first. That's item number I. In circumstances.
Why is that fraud?
It's collusion, Your Honor, because.
Collusion. I mean, it's an attempt to resolve a dispute with your
No,
client.
Your Honor, it's an attempt by a supposedly independent investigation to sweep under the rug the things that caused him to be charged initially, which was his disclosure of financial improprieties by the members of the firm who hired this firm to do the investigation. Your Honor, just really quickly, I would draw the court's attention to two cases, one of which is out of this court, the Joel v. Weber case, which is 602 New York State 2nd, 383 at 396, 397. This court specifically said, lacking merit is defendant's contention that as a law firm it is immune from aiding and abetting liability for merely having provided legal advice to the client. Under New York law, an attorney may be liable to third parties for actions taken in furtherance of his role as counsel on proof of the existence of fraud, collusion, or bad faith. Then I would draw Your Honor's attention, and I'll save the rest for rebuttal, to Cone v. Davis, which is a Southern District case at 926 F. Sup. 399. That was on a motion to dismiss a tortious interference claim where the defendants had been alleged to engage in self-interest because they wanted to prevent plaintiff from revealing potential financial improprieties, and that defendant used fraudulent means, like we contend they used here, to effect plaintiff's termination. If Your Honor's plea, nothing could be clearer than those cases.
Thank you, counsel.
Good afternoon. May it please the court. My name is Evan Krinick, and I'm here today on behalf of the law firm of Putney Twombly and its partner, Michael Yim. This case is the perfect poster child for why there needs to be immunity for these type of claims. My clients were hired first to prepare an employee manual, and then were brought in to do an investigation after allegations of sexual assault by a partner of the law firm. They conducted their investigation. They did what they were asked to do by their client. And now they're being drawn into this incredibly acrimonious revenge lawsuit between the former partner and the law firm.
But they claim that the former partner was not impartial, right? That basically you gave access to another partner's email and Yim wrongfully precluded plaintiff from having an attorney present when he was interviewed.
Well, the good or bad of the investigation, and we think all those allegations are misinformed, but the good or bad of the investigation is not a basis for a lawyer to be sued by.
So Mr. Yin could have been wrong and he's still immunized.
He doesn't get sued in a lawsuit, or else no lawyer in the right mind is going to get involved in an investigation where they know whatever result they reach, they're going to be sued by the adversary, somebody who's not their client. Of course.
You actually, I think it's true when you read the briefs that the parties are not in disagreement over what the law is.
Correct.
Right, and so what we really need here is to look to see whether there are factual allegations, which we're going to presume are true, which would support any claim of fraud, collusion, or bad faith. Is that right?
That is correct, and you could read that second amended complaint as many times as I have, and you're not going to find any well-founded facts. Facts, not suppositions, not inferences, not wild conspiracy theories that the alleged sexual assault victim got in a room with firm management and their outside counsel and cooked up this whole theory that we're going to make up allegations of sexual assault, we're going to do a sham investigation, we're going to find this guy guilty, and then he's not going to squeal about the world about financial management. I mean, it's all allegations and spurious, but there are no facts there. It's nothing my client as a lawyer, he has no stake in this dispute. He has a right, Mr. Lewis, to sue his law firm. They can sue him back, but the lawyer, the outside counsel brought in to do an investigation should not be drawn into this lawsuit. That's what the immunity is there for, and it has to be enforced at the 3211 standard. If you allow this kind of complaint with allegations like this to go forward, well, frankly, the immunity is worthless. The reputational harm for being sued, the cost of discovery, all to get the summary judgment to prove that it's all without any merit, because there never was any factual basis for it, well, you might as well just get rid of the immunity, because no law firm, no professional liability carrier is going to insure a lawyer that's likely to be sued, all the more so in the workplace harassment environment. You certainly need to have a lawyer come in and do an independent investigation, give advice to their client, and not be concerned about being sued by the adversary.
Thank you, counsel.
Thank you.
If Your Honor's pleads, words have meaning. And I heard my adversary say several times, you're never going to get a lawyer to do an independent investigation. The factual allegations of this complaint indicate that there was never an independent investigation. In fact, Mr. Yim acknowledged that in connection with his investigation, when he offered the plaintiff the opportunity to author the findings, that he was not objective or independent, but rather he was representing the firm that had allegedly retained him. What's also interesting...
But that's true. That doesn't mean it's fraud.
No, it doesn't, Your Honor.
I mean, that just reinforces the idea that he was acting as an attorney, right?
But that alone
For
does
the
not
firm.
immunize. That alone does not immunize. Your Honors...
Actually, that alone does immunize him.
Not in the
Let me
face...
finish.
Oh, I'm sorry, Your Honor.
It's the extra, and we all agree on this, it's the extra allegations of fraud, collusion, or bad faith that would take you out of that immunity. You start off with it, and then you have to have allegations of this other stuff in order to go forward. And so the question, honestly, posed by the resolved by the lower court and posed by this appeal, is whether the facts as alleged in the complaint are sufficient for that heightened standard, right?
That's right, but that's not what the lower court did. The lower court did not consider any of the factual allegations. All the lower court said is, if you repeat the words fraud, collusion, malicious...
No, but the court considered it. He just thought it was conclusory.
No, they did not consider items A through M on page 6 and 8 of the initial brief. If Your Honors please, what would be very instructive, if you would look at the cases cited in our initial brief at pages 28 through 30, those cases upheld independent lawyer liability in cases much less egregious than this. And you remember, Your Honors, this is a pre-answer motion to dismiss.
We got it. We got it. Thank you, counsel.
Thank you. You have a lovely day, Your Honor.
See, Jason?
May it, excuse me, may it please the court, John Newberry for the Legal Aid Society appearing for appellant. The previous case argued was about an investigation. There's an investigatory aspect to this as well. This case is about access to impeachment information, specifically information about police misconduct. The appellant is charged as a juvenile delinquent with possession of a weapon in family court.
Tell me specifically, what is the impeachment evidence or the impeachment information that you requested that you did not get as part of the initial turnover of Brady and Rosario material?
Well, it's hard to answer that, but let me try. We asked in our discovery, in our discovery motion, for information equivalent to the disclosure that defendants get under 245.20, 1K4, if this were in criminal court. And that statute...
So you're drawing no difference between, at least in that respect, from family court proceeding and criminal cases in regular court, right?
I'm sorry, what the first part of your question?
You do not draw a distinction.
Well,
between your ability to impeach an officer and a juvenile
Correct,
delinquency
correct.
proceeding or regular.
Exactly right, Your Honor. The right of confrontation under the Sixth Amendment is no lesser stature or value to a juvenile in a delinquency proceeding than it is in criminal court. Police officers are just as subject to cross-examination in family court as in criminal court. Now,
But specifically, what you want here is for the court to apply the disclosure requirements that are now applicable to criminal proceedings to this juvenile delinquency proceeding.
yes, in effect, but not literally, since 303.1 in the Family Court Act specifically prohibits literal application. We want equivalent application.
All right, and the statute, let's follow this through a little bit.
Sure.
So the statute in the criminal context is not constitutional. It's a statutory requirement.
Correct.
And it's something that actually exceeds the constitutional requirements of Brady and Rosario, correct?
Yes, I think courts that have considered that on the criminal side have so held.
Right, so your argument, as best I understand it, is really an equal protection argument.
That's correct, Your Honor.
Not under the Constitution, just that these juvenile delinquents are similarly situated to the criminal defendants in terms of the need for information to otherwise defend against very serious charges.
In a nutshell, that's exactly it.
But if a distinction in discovery rights raises an equal protection issue, why isn't there an equal protection problem with the lack of grand juries in family court or the lack of jury trials in family court? Wouldn't it be subject to a similar equal protection analysis?
I can't speak directly to the lack of grand jury. I think certainly the Supreme Court addressed, and I think it's Pennsylvania v. McKeever, that in terms of jury trials, that just really is not, given that juvenile proceedings are different enough in terms of their purpose and the sort of the context in which they occur, that it's just not workable, so that not requiring juveniles to have jury trials doesn't really kind of rise to the level of depriving them of any constitutional protection. But I think this issue, Your Honor, goes directly to the right of confrontation, the ability of any accused, whether in family court or in criminal court, to test the credibility of and possibly undermine the credibility of the very witnesses who will testify at hearings to determine what evidence is admitted at trial, and if there is a trial in this case, because there are going to be both suppression hearings and possibly a trial, whether those witnesses can be, what their testimony is going to be that's going to go directly to proving guilt or innocence.
So there's a bill up in the legislature.
Correct.
That is designed to otherwise address this issue. What's the status of that bill?
My information, the status of that bill is there are companion bills in both the Assembly and the Senate. We're in I think, about to start in January, the second half of the two-year legislative session. The Senate bill was passed at the very end of the last part of the session, and the bill and these companion bills are identical in scope. And by the way, they were drafted essentially by the Office of Court Administration. So they, as you can tell from, as mentioned in the briefs, these bills essentially import into Article 3.
It passed the Senate.
It passed the Senate. It's now is in committee in the Assembly. I mean, they haven't reconvened, so I don't know what the status is.
But if it's the Assembly, your guess is they're going to have more protections rather than fewer, right?
I'm sorry?
Just kidding. Just a bad joke. I think we're good. Thank you, Counsel.
Okay, thank you.
So this is a runaway train as far as you're concerned.
That's exactly right, Your Honor.
So tell us why we shouldn't do what's being asked of us to do, particularly when the legislature seems imminently going to be exercising their own legislative choice in this issue?
Sure. That's exactly right, Your Honor. And just for the record, Assistant Corporation Counsel Deborah Wassell on behalf of Respondent. Just to address Your Honor's question, the legislature is contemplating these changes, and if it decides to enact that law, it should be free to do so, but as it applies to family court. The CPL provisions, as they're written, frankly, are impossible to apply in a family court setting for the reasons that we point out.
Well, not technically, but the concept of providing a more robust discovery can certainly be applied in juvenile delinquency proceedings in family court. That's the underpinning of those statutes. It's a more robust discovery than you otherwise get under Brady and Rosario.
Well, I can express that my office makes those determinations of what we disclose without regard to the materiality standard, and so
I'm curious as to why you just made the statement that you seem to be suggesting that somehow it's unworkable in family court.
Well, because the purpose of these laws and the major difference is that it imposes these time restrictions. And so when you're looking at the way the law is structured, where it says it has to be disclosed within 15 days of arraignment, there are very specific time requirements, and that's what I'm talking about when I say that is not practicable for family court proceedings.
You know, that was the same argument, I think, that was made a couple of years ago by the district attorney's various offices in terms of the time restraints. Should we not be looking at the substance of the materials? The fact, especially in this case, where you're talking about 14 police officers, I think at least 9 of which had some type of complaint or CCRB complaint or litigation, pending litigation.
All of which has already been disclosed, Your Honor, and that's been made clear in our brief and to appellant. All of that information has been disclosed.
How was it made disclosed? By that letter that was sent to petitioner?
So the initial, the VDF form, the voluntary disclosure form, gave some of that information, and we provided additional information from the substantiated NYPD disciplinary proceedings, as well as the CCRB records within our possession. And so all of the material.
I thought that most of what you gave were summaries, that you didn't give the primary documents underlying the complaints made against these police officers.
They were submitted in the form of disclosure letters, which summarize those information, that information, excuse me.
Right, but the actual reports, the actual files and reports were not turned over.
Right. Rather than summaries.
Right, rather than summaries.
That was not litigated in this case, and that's not what the juvenile is asking for. The issue in this appeal is simply whether or not the CPL provision applies on its face, not whether the specific documents that would be disclosed under any purported expansion of the discovery rules would be turned over. That is an issue that probably needs to be litigated, but this case is not the case to do it in because it wasn't raised, it wasn't briefed below, and it wasn't the basis for the family court's decision.
Okay. Are you with the corp counsel or?
Yes.
Oh, you are with corp counsel, okay.
So what's the rational basis for treating a juvenile delinquent with respect to discovery differently than an adult criminally prosecuted person?
Sure, so there are many. Criminal defendants are obviously differently situated than juvenile respondents. Criminal defendants have, maybe facing much longer prison sentences. Their loss of liberty, the risk of loss of liberty is obviously much greater. And frankly, the way the system was structured before the new CPL provisions, criminal defendants could be sitting in jail if they were remanded or in jail on bail.
But again, all that's changed now with the bail reform. And in terms of one facing higher penalties than the other, you could make that same argument where someone in criminal court is faced with a misdemeanor as opposed to being faced with a felony, because obviously the penalties for a felony are higher than those for a misdemeanor. So I'm still not understanding the correlation between the two.
So the standard that you need to look at in terms of a rational basis review is whether there's any rational and legitimate government expectation, objective to support the law. It doesn't need to be any one in particular, and in this case, there are many. juveniles and adults are just not treated the same. That's why we have two separate statutory schemes.
But the jeopardy that they facing is similar, right?
No, that's not true. Adult defendants can face, obviously, you know, as I've mentioned, much longer sentences. You know, juveniles, we're talking about, even if they get restrictive placements, which
So
most
you
of
don't
the
think a
time.
JD adjudication, well, I'll leave it at that.
Well, a juvenile delinquency adjudication is not considered a conviction for, you know, for future purposes. Those records
Except
are,
perhaps on the federal level, because in some instances on the federal level, the JD can be considered.
well, juvenile police records are required to be withheld from public inspection. They are not allowed to be used against the juvenile in future court proceedings. That's set forth in the Family Court Act. And so for those reasons, they're very differently situated.
Okay.
Counsel, I just want to ask you a question.
Sure.
So, you know, with respect to the right to confront witnesses and to present a defense, I mean, you would agree that those are fundamental rights, yes?
Yes, and
Okay.
the juvenile
So,
in this.
I want to go forward with that. So what respondent is asking for is information regarding these police officers, many who, you know, are the subject of disciplinary action. The people, they have that information. So how is it different for a criminal defendant to get that information, but not the respondent?
The disciplinary records have been disclosed, and they will be disclosed in the future because those are those are required under Brady and Giglio and Rosario, which are pre-existing obligations to which the presentment agency is subject and will continue to be subject. So the adult defendants are not getting anything additional. We're disclosing anything without regard to materiality. So even if it has nothing to do with the instant case, we're turning it over, and that is what has been disclosed in this case. So the juvenile in this particular case has received
Clearly,
that
there's
information.
material that hasn't been disclosed that they're after, right?
The family court determined that
In
all of,
addition to the Rosario and Brady material that was allegedly turned over.
no, Your Honor, there is nothing additional to which the juvenile is entitled under the Family Court Act.
No, that's not the question. You saying they're not entitled to it, clearly they claim that they are. That's the debate, right? Otherwise you wouldn't be here if you all agree on it. But let me just, I think we've had enough in this case. Let me get you a minute, you know, and that's it.
A couple of quick points. My adversary points out to how unworkable the 245.20 section is. We're not asking for importation, literal application. Obviously, it's a nuanced situation. It's be different.
So just to clarify that, you're not arguing about the time periods. That's not what's ailing you. You want the substantive information, the impeachment information that a criminal defendant would be entitled to that you have not gotten here.
Correct. Correct. As to the
So
sum,
specifically, what is it that you want here that you haven't gotten?
well, ideally, we would like all of the underlying disciplinary records, which are, so far as we know, we've got these summaries. There's no the underlying records which are being given to defendants in criminal court under this section. We haven't seen those. If there's any representation that that's been provided to us, that's news to me. The record would not support it, I would argue. I think I cited in the brief, Reed v. Jones has kind of put to rest any idea that these aren't quasi-criminal proceedings, that the juveniles don't face serious
got that.
consequences.
Yeah.
Okay,
Good.
thank you.
Thank you both. Okay, Hamapore versus Haronian. Remember that Hashim versus Osorio will be called last.
Good afternoon. Thank you. My name is Glenn Lenahan with Oved & Oved LLP for the appellant. Non-party appellant Shahryar Hamapore is the husband of plaintiff Mernaz Hamapore, and this appeal concerns a decision by the special referee that was affirmed in an unexplained order by the lower court, holding that appellant somehow waived nearly all of his privileges, including the privileges afforded by the common interest, work product, and trial preparation doctrines.
Well, he claims that they were boilerplate general objections, were they?
No, Your Honor, and I can show you very clearly in the record that they were not. If you go to the responses to the subpoena are on pages 221 to 230, in which case they are spelled out expressly in response to each of the appropriate demands. This isn't a case where we just said that we're withholding based on privilege. It expressly says documents protected by the spousal privilege, attorney-client privilege, common interest privilege, attorney work product doctrine, and as trial preparation material.
You didn't give a privilege log at that time, did you?
No, Your Honor.
Weren't you required to?
Not at that point.
Why do you say that? Aren't you supposed to put together all the documents, put forward a privilege log, in the privilege log, identify the privilege that attaches to each particular document so that it wouldn't be boilerplate?
Your Honor,
and wasn't it, and let me finish.
Excuse me.
Wasn't it the case that no privilege log was ever put together until after the decision on the first motion to compel?
The protocol that we entered into, all the parties entered into with the special referee said that a privilege log would be produced 30 days after completion of production. At this point, the appellant had only made a partial production, and in fact, the parties were still negotiating search terms.
The special referee said, gee, don't I need a privilege log? And didn't you folks say, no, you got enough here to make a decision, right?
Only regarding the spousal privilege and the agency exception to the attorney-client privilege.
I mean, didn't you self-limit by then?
No, Your Honor. Respectfully, we did not. We brought up all of these other privileges, not only in the responses and objections to the subpoena, but during 2 meet and confers and in a letter to Justice Cohen in the lower court when we corrected a misrepresentation that we hadn't raised those other privileges. The respondents then filed a dispute letter number 5, with the special referee that only raised the spousal privilege and the agency exception. We opposed that letter, and the special referee on page 819 of the record expressly said, I'm directing briefing on the issues raised in dispute letter number 5. The issues raised in dispute letter number 5 need to be briefed by the parties. Everybody understood that because the respondents in their moving papers only addressed with respect to appellant the spousal privilege and the agency exception.
Because that was what was in the letter, right?
Exactly. So respondents had full knowledge.
That's not indicative that they had a belief that there were other privileges out there.
Your Honor, what is indicative is the repeated and consistent assertion of those other privileges in the subpoena responses and objections, in the meet and confers, in the letter to Justice Cohen. And there is not one decision cited by anyone in these circumstances where a full waiver of privilege was ever found.
So in your first response to the subpoena where you theoretically reserved all this, did you raise the common interest privilege in that?
Yes, Your Honor.
You expressly said that?
Spousal privilege, attorney-client privilege, common interest privilege, attorney work product doctrine, and its trial preparation materials. At all relevant times, it was always disclosed. Respondents went ahead and filed a dispute letter on the narrow grounds of spousal privilege and agency exception. We opposed that on those grounds. Direction was given to brief those specific privilege exceptions. At no point could the appellant have ever considered that by addressing the arguments made by respondents and addressing those arguments only, he would somehow be found to have engaged in a wholesale waiver of all of his other privileges. And none of the case law anywhere supports that. In fact, one of the key decisions relied upon by the special referee in his decision, McNamee v. Clemens, shows how there was no waiver of privilege. There in McNamee v. Clemens, the court expressly found that defendant technically waived his right to claim privilege as to any of these documents because he failed to timely provide a privilege log. The court then provided an inadequate log, and when submitting documents for in-camera review, the court said, most importantly, he deliberately withheld these documents from the court despite the court's clear and unequivocal order to produce them for in-camera review. Nonetheless, the court still allowed the defendant to maintain these privilege assertions and directed the defendant to submit those documents for an in-camera review. So even there, where there was a willful and contumacious failure to comply with a court order, there still wasn't found a waiver. All the appellant did was follow the rules that were set forth by the special referee. He said, brief these issues. Those were the issues that were briefed by the respondent. We opposed those arguments that were made, the actual arguments that were made. We are now in a situation where the respondents are saying, we didn't contest your other privileges, so now you have waived them. All of the other decisions that are cited in the decision that we're appealing and the respondents' papers involve situations where someone they were at the stage of the litigation where they produced a privilege log and either failed to enumerate certain privileges, thus waiving them, or it was an opposite situation where someone was seeking production based on a privilege log and didn't make an argument.
We got that. We got it, counsel.
Thank you.
Let me hear from the other side.
Good afternoon again, Your Honors. May it please the court. William Sharon from Prior Cashman for the respondents.
So why did they waive privileges that you did not raise in your motion to compel?
So here's what happened. They put in their list of objections, perfunctory, and we met and conferred about them for 45 minutes. The only thing they said, because it was their burden to explain what this laundry list of objections meant, they mentioned the common interest privilege. It was the plaintiff's common interest privilege because there's a consolidated action and another plaintiff, and they are in a common interest. And the only argument made by the appellant was that his role as spouse meant that all of her privileges, common interest, work product, attorney-client, all velcroed to him as well. That was it. They keep saying that there was more that was put out there. There was none. The reason that there was
no argument made that because when he became the trustee, that then he was on the same side of his wife in terms of the position in this litigation, that they had a common interest in terms of things like attorney-client. No?
Never, not once. You can scour this record, Your Honor. You will never see the words trust or trustee used in their written objections, in the pre-motion correspondence to the court.
On August 26, 2020, there's a decision on a first motion to compel. And the special referee held that Shahriar had not met his burden to withhold documents.
Your Honor, I'm so sorry. I'm deaf in this ear. I just didn't hear you.
Okay, so what's the effect of the August 26th? What role does the August 26, 2020 decision on the first motion to compel,
right,
where the special referee held that the appellant had not met his burden to withhold documents on an agency basis, and there's no exception filed to that?
Correct. So what happened was, at first, it was all about spousal privilege. Everything attached to him as spouse. We offered authority saying that's not how the spousal privilege works. They dropped that, changed it to agency, which was not even mentioned in their written objections. That was and that was it. And our motion to compel at records pages 266 to 283, we responded, the referee directed us to bring a motion to compel, not them to bring a motion for a protective order. There's this fiction that they just responded to us. We brought a motion based on the pre-motion practice. That's the point of pre-motion practice. But still in our motion, we specifically sought complete production of all documents without any privilege assertions. Literally, the last words of the brief are without any privilege assertions.
And no privilege assertions were made in response to that
Nothing about the trust at all.
Other than, right.
And at the same time, in the same brief, through the same counsel, the appellant's son was making multiple arguments. And he won on one of his alternative arguments. He's a lawyer. He claimed agency as well. He also claimed an attorney-client privilege because he knew, they all knew they had to put it all on the table.
Can I ask you a question? Because this puzzles me, and I asked your adversary this, and I'm going to ask you, why wasn't there a privilege log early on in the case, which would have obviated almost all of these disputes here?
I wanted to answer that. I'm glad Your Honor asked. So the reason was, and they specifically agreed to this, and the referee was there and found it. He was there firsthand. He knows this is what happened. He asked, is this ripe? Don't you want to put in a privilege log first? And they said no, and we agreed that there was no need because they only had one global omnibus argument. Everything was privileged under the agency or spousal privilege. Nothing about the trusts, Nothing else needed to be said. It was very tidy in their view. It's all privilege because of the agent. They lost that, they didn't take an exception for it, and only then did they come back with this belated and equally baseless argument about common interest, which of course this court has the right to review if it wants. Thank you.
Thank you. Thank you, counsel.
I'd like to address certain of the issues that were just brought up. First, in saying that we have never raised the common interest privilege, it's just wrong. In our September 23rd letter to Justice Cohen, in response to their letter asking for a conference on the subpoena issue, on 238, we said that we further advised Respondents' Counsel that the request in the subpoena called for the production of documents protected by the attorney-client privilege, common interest privilege, attorney work product doctrine, and as trial preparation materials. It's September 23rd, 2019. They never wrote to us saying, no, you didn't say that. They never wrote to the court saying, no, you didn't say that. At all times, the common interest, Shahryar's, Hamapore's common interest has been raised and at issue. Their argument that Jeffrey, who is appellant and plaintiff's son, made a new issue, made a new argument in the motion is just false. In their letter, their IDL number 5, they specifically argue Jeffrey has made an inapplicable assertion of attorney-client privilege, and Shahryar and Jeffrey's new agency theory of privilege is unsupported. So that was in IDL number 5. And in opposition, that's on 260, 261 of the record. In opposition to IDL number 5, 262 to 264, we argued against that specifically. We argued that Jeffrey is her counsel, that Shahryar is her agent, and we added a footnote, because we were limited to 3 pages, that in the event you find that Jeffrey is somehow not plaintiff's counsel, Jeffrey has unquestionably acted as plaintiff's agent. So everything that was briefed, everything, was what was raised in IDL number 5. Now, with respect to how we came here, respondents bowled forward and insisted on having this briefing done. We agreed with them in front of the special referee that there's inarguably a dispute over whether the agency exception to the attorney-client privilege applies here. The spousal, they had admitted that they weren't seeking documents between appellant and plaintiff solely. So they said, this is the issue, and we agreed it's an extant issue. They asked for briefing. We said we could brief the issue because it's going to affect what we search for, how it's searched for with search terms, and what ends up getting logged depending on, pursuant to the parties' stipulation that they entered into regarding ESI and privilege logs. So all of this in no way can be considered a waiver. We addressed the arguments that were put before us. There is not a single case anywhere that supports waiver in these circumstances. And in fact, the law is clear. You have to look to the facts that led to this waiver. This wasn't a situation of voluntary disclosure to someone that you knew was going to turn it over to your adversary. Not that situation at all. Here, what has been held is that because appellant argued against the arguments that were made, pursuant to the special referee's own limiting directive at record site 819, somehow he waived all of his other privileges, despite the fact that his production was not complete, the search for documents was still ongoing, and a privilege log had not yet been served. And there was no expectation by anyone that this was going to somehow avalanche into...
Thank you, counsel.
Thank you.
New York Dangerous versus LeBron. Let me first hear from New York Dangerous.
Good afternoon, Good afternoon, Your Honors. I'm not a practicing attorney, and I have Asperger's syndrome, so I apologize ahead of time for reading our argument. First, a housekeeping measure. As instructed by the appellate clerks, each motion to vacate dismissal and enlarge the time to respond for our 4 appeals was e-filed jointly together under today's single case number, including paperwork for all 4. Your Honors will note all appeals included in the perfected record on pages 553 to 560 and enumerated on all of our headings. For example, 561, our CPLR 2015 certification. None of those appeals were abandoned. Each attempt at perfecting
with all 4 appeals included, was filed timely but rejected as technically flawed, necessitating our present and final combined motion to vacate and enlarge, covering only 2 questions, both crucial to our recovery. Question 1, did the trial court commit reversible error in dismissing our financial cause of action via res judicata, where the parties, subject matter, and causes of action were all different? And question 2, did the trial court commit reversible error in dismissing both plaintiffs' cases, but continuing defendants' counterclaim when plaintiffs missed preliminary conferences of which we never had notice? This court retains independent authority to address both questions in the interests of justice, even if all 4 appeal case numbers and supporting documents hadn't appeared in all of our pleadings, and both questions weren't argued by respondents and appellants' pleadings, which they were. Cases should be decided on their merits, especially when equity favors it and there's minimal prejudice to other parties.
What is your meritorious claim?
Under Latha Restaurant, potentially meritorious is a low bar of showing triable issues of fact, and it's easily met, particularly by conflicting testimony on the underlying facts. Whether respondents' actions were justified in converting funds from plaintiffs, appellants, in context is a question of fact requiring trial. Cases should be, sorry, I apologize.
You're talking generally. I think that what my colleague was asking you specifically, what is your meritorious claim here? Not just that, you know, what the standard is for what a meritorious claim is, but what do you say here that shows you have merit to the claims that you are making?
There are 3 causes of actions in our claim. One is that defendant converted over $15,000 of money without permission. There's a question as to whether that was done with permission or without. He disobeyed instructions and filed for case, I apologize, Your Honors, filed for,
yeah.
I'm sorry, it's difficult.
3 minutes goes fast, I know.
Yes, it does. I apologize. And if it's okay, I'd like to.
I'll give you an extra 30 seconds, but this is the end of the day after a long day.
I understand and I believe it. Our reasonable excuse for missing the preliminary conferences is we had no knowledge they existed. As shown on the record on page 470, I was only using e-file to follow the case and didn't even know e-track existed as a separate login until the dismissal was e-filed. No case law upholds dismissal without actual knowledge, especially under Latha and under equity. Lack of actual knowledge requires reversal of dismissal, and I'd like to talk more about res judicata and any other questions you have in rebuttal.
Thank you.
Hey, Adam Libro, pro se, respondent, defendant. Yeah, there's not much here. I think you touched on it. The meritorious cause of action is the one that I couldn't find, except a statement that there's a verified complaint. But in that case, no plaintiff default would ever really require a meritorious cause of action because there's always a verified.
Well, he claims you took intellectual property that belonged to the organization. Did you?
No, no, no. It didn't belong to the organization. It always belonged to me. He didn't claim I took it. He claimed I registered a name, 4 names, and he claimed that he should have been the one to register it, but he didn't, as I mentioned in the brief, he hadn't registered it in the 4 years and had no interest in it, so I registered it in 2016. It was generic names. The words New York and dangerous were some kind of combination, which are not specific to intellectual property, and very generic names. I've never used it in any course to compete or to do anything adverse to the club. It's essentially a social club, and so he didn't show any harm that came of it, any damages that they suffered because I registered and possessed these names. I didn't take them from the organization. They were never in possession of the organization.
Okay, thank you. I'll give you the rest of his time, which is about 1.5 minutes, so.
Thank you, Your Honors. The other meritorious claims we have are over the conversion of over $15,000, which he took. And then there's obviously a question about that, as well as other claims that we made are relatively easy to prove, but we have to get to trial first. The bar
for pre-trial hearings for whether or not there's meritorious claims extremely low. The judge has already overcome.
Yeah,
before
but
the
you
dismissal-
also have to show a good reason for having missed the two conferences, right?
Yes, and under Latha, I'm sorry, I didn't mean to interrupt you.
No, it's fine.
Thank you. Under Latha, we clearly had no knowledge. It's undisputed that we did not know. I am not a practicing attorney, as I mentioned. I could not afford
Didn't you have an
counsel.
obligation, once you filed a suit, to make sure that you knew how to track it? I mean, isn't that basic,
Again,
attorney or not?
It may seem that way, and I thought I was tracking it every week via, there are apparently two different things. There's e-file and e-track.
Right.
I was
You
following
track and
e-file.
NICEF. You were
Everything-
following NICEF, you said.
Yes, everything was followed on e-file. I did not know e-track existed until I received on e-file the dismissal. We simply did not know, and I
You
can,
didn't get emails.
no, there were no mails, there were no emails, there was nothing at all. And we've been pursuing this case for years, and we've been involved at every step. There's no way we would have not participated had we known. The last question is that the other appeals are over the singular issue of res judicata, the trial judge's order, then his denials of our motions to reconsider and re-argue. The judge denied in court respondent's motion, but his written order reads, in retrospect, dismissal of plaintiff's cause of action, singular, is warranted under res judicata grounds.
Okay.
Plaintiff New York Dangerous wasn't even recognized by the trial judge.
Thank you. Thank you so much. Your time ran out. Thank you both. And last is Hashim versus Osorio. I am recused from this case.
Thank you. All right, last but not least, right? You can proceed,
Please,
Counselor.
the court, Guy Rega for the, of Zucker and Rega for the appellant plaintiff. The essential allegation made by the plaintiff in this case is that there was a delay in diagnosing a condition. It's called heparin-induced thrombocytopenia.
Right, so when do you say that that condition should have been diagnosed? I mean, that's the key. Do we have an issue of fact about when it should have been diagnosed? It was diagnosed and effectively treated October 8th, right? By that time, they had discontinued the heparin, and they put her on an anticoagulant, which is the protocol, right?
Correct.
All right, so when should they have known earlier and administered treatment before?
Okay, so according to appellant's expert, by September 25th, 2015, this was 4 days after she was first administered heparin, appellant began exhibiting cyanosis of the tips of her fingers. This was on the record, page 9927. Appellant's expert explains that this was significant because cyanosis refers to blue discoloration.
Right, we know that, but,
Yes.
but we also know, I mean, you all agree, and just because it's a long day, I'm gonna try and focus this a little bit. As I understand the papers, you both agree that the protocol for diagnosing or for actually proceeding to the assay test is that you have to use a tool indicative of certain factors, and when you accrue enough points, then you move forward.
Yes.
So the fact that on the 25th, there was certainly a decrease in the platelets, and there were the blue fingers, but that wasn't enough to get points. And in fact, your expert says that the point system didn't really exist. She didn't have enough points for the further testing until September 25th, right?
So actually on September 28th, 2015, the platelets had dropped by 30%.
I mean 28th, right.
On the 20th, actually.
I'm sorry.
So actually on that date, there were enough points. And appellant's expert states that the HIT score, if it was calculated on that date, would have been more than 5 points. 1 point for a
I know he
thrombocytopenia.
says that, but the question really is that actually, is that supported by the record?
So
the
actually,
record.
he explains the
So,
point
right,
breakdown.
I know I'm sort of rushing you because it's a complicated case.
That's okay.
And you're really familiar with it, so I don't want you to think this.
So if I may
It's all
just say,
turning on this, but I have your expert's affidavit, so let's look at what he says existed on the 28th. By the way, what was the date of surgery?
that was September 28th.
Same day, right?
Actually, yes, later.
Same day.
Later that day, and this was.
Same day that your expert said there were enough points to otherwise move forward with a more.
Prior to the surgery, correct.
Yeah.
And,
okay.
and if I may, one point out of those points was for what's called thrombocytopenia, which
Right,
was the level.
and I know there's a dispute about whether, about the baseline, but let's leave that aside for 1 minute, and we're going to give you the 1 point. Okay.
Okay.
Next.
2 points for her clear onset between 5 and 10 days of the administration of heparin.
Right, and that seems to not be disputed either, that.
Actually, that is disputed with the defendants. They
Wasn't
dispute
it
that.
only 3 days, 3 to 4 days?
So between 5 and 10 days is when you get the 2 points. And actually what the defendants, and this is the primary issue we have with the improper issue determination
But didn't
by
you
the
use a
lower court.
measurement from the 3rd to the 4th day?
I'm sorry?
Didn't you use a measurement from the 3rd to the 4th day, which would be too early for it to show up? If it was HIT?
So for HIT, there's this calculator they call the 4T calculator. And what you have to do is go through each of the factors. And using that calculator, between the, if you get 2 points for a clear onset between 5 and 10 days. And that's what, and the defendants, one of the things they do.
But from your reckoning, didn't the onset start on the 3rd to the 4th day, which would be too early to be an indication?
So actually, so the first day in which heparin was administered was September 21st. And
October 21st?
September 21st.
September, excuse me, that's when she was admitted, right?
Admitted and given the first dose of heparin, which the defendants fail to address. They essentially just ignore plaintiff's essential allegation in this case.
Wait. I want to go back. I don't want to get way late on this because honestly, this is really key about whether your expert's calculation of points on the 25th comports with the record.
28th, correct? Yes.
I know,
Yes.
I keep saying the 25th, I'm sorry.
That's okay.
28th,
Mhm.
right? You did, right, the 28th. So the onset of the, well, let's go to item 3. Then you go 1 point for suspected thrombosis, which had not yet been proven.
Correct.
Well, not only had it not been proven, where is the evidence in the medical records that it even existed for you to get 1 point when, as I understand it, nobody knew about the thrombosis until there was a test given on the 8th.
Actually, they knew because the evidence of the thrombosis, as explained by the expert, was the cyanosis of the tips of the fingers on September 25th, 2015.
Which brings us to the last piece.
Yes.
And this is where I really think your points really fall apart, which is no apparent cause for the thrombocytopenia. There were other rule-out diagnoses, at least 3 of them that I saw in the record. One, she had Raynaud's disease. She told them that her fingers frequently turn blue. It happened before, it's happened 3 months before, it comes and goes. 2, she had vascular disease, another reasonable cause for what was going on with her. And in fact, they did call in vascular consults. And 3, the last one, which is not addressed by your expert, none of these are really addressed by your expert, is the fact that post-surgical, there is frequently a drop in platelets for everybody. So that was a possible explanation. So given the other possible causes, how can you get 2 points for no other apparent cause for this? I just don't see how the points add up.
If I may, Your Honor.
That's my question to you.
Thank you. If I may, I assure you that neither my papers nor his, and I know this is a lot of factual issues here, Nobody said here that Raynaud's phenomenon, which is a blue discoloration, can cause or be associated with low platelets. So that's some type of overlooking of what we said in the papers. Nobody said that
No,
because
no,
that's not.
and I didn't say that either.
Okay, I think you were saying that the three
No,
causes.
no, I said for no
For n-
other apparent cause for the blood clot.
Exactly. No
Got
other
it.
apparent
That's
cause
the
for
2 points.
thrombocytopenia.
Yes.
And you're saying that Raynaud's phenomenon, nobody here says that Raynaud's phenomenon could be a known cause for thrombocytopenia. Nobody also says the second one you
For the
said was.
blue no, for the blue fingers. You're
But no,
saying the reason
for
that
the
we
category.
knew that she had the condition is her fingers were turning blue. And what I'm saying to you is there was another possible reason for her fingers turning blue.
That's not the category you just referred to. You just referred to, Your Honor, and correctly, to no other apparent cause for thrombocytopenia, not to blue fingers. So saying that Raynaud's phenomenon, do you see the difference
Well, then
there?
I guess that would go, then you take out the 1 point for the suspected thrombosis, because there's another explanation. Go ahead.
Except here, they're saying that it's not been proven for suspected. They did not prove Raynaud's. They did not prove any other cause. And regardless, Your Honor, and I do appreciate you getting into those issues as well, our expert explains and has an opinion that the suspected thrombosis that has not been yet proven is associated with those blue cyanotic discoloration.
But wasn't there also other explanations for that?
Again,
So then how do you get the 1 point for the thrombosis?
again, Your Honor, so the no explanation is only for the category that has to do with the thrombocytopenia, which is the low platelets, does not have to do with the cyanosis in that case. Okay? And I will tell you that that calculation that's made was made on that date, prior to the surgery on that date, by the data that was available on that date. So regarding the third category you were talking about, the surgery dropping the platelets, that would not be relevant on that date, but he even calculates it after October 28th. And just to point out, it's also, he calculates it on October 2nd, and then when the fingers were getting noticeably worse. So I will say, I know, Your Honor, that the calculation here is not a simple one for us perhaps today, but our expert clearly explains his reasoning.
Is the calculation the sole basis for a determination as to whether or not there was a departure?
Absolutely, and not only that, but also what defendants fail to do here is that a big part of the calculation is determining what the baseline date was.
Yeah, exactly, and that was the question that we started out with, was
Yes.
what was the baseline date, and so what's the baseline date?
Absolutely, the date, this is very simple. The entire case is about having an allergy to a medication. Wouldn't the baseline date be the date in which the medication is first given? This is simple common sense. For some reason, their expert somehow tries to shift that usage of basic human common sense to having it after the surgery, perhaps. And they do not address and don't say.
So it's your position that a pre-surgery date is the common sense one?
The common sense date is the date in which a medication for which we're alleging an allergy to was administered.
So that would have been the 21st.
Correct.
And the surgery didn't take place until the 25th.
28th, correct.
28th, I'm doing like two.
It's okay, yeah.
Okay, so again, so you're talking 7 days after her initial, and her being admitted to the hospital. So again, as Justice Friedman just stated, you're looking at a baseline date prior to the actual surgery.
Of course, the baseline date has to be.
Why is that of course? That
I'll explain it.
It doesn't take account of the fact that you're administering medicines, their blood transfusions, this surgery, all of that is going to cause fluctuations. You're not going to get an accurate picture if you take a date which be at the beginning of this process.
Your Honor, we're talking here about taking a medication. We're alleging a delay in diagnosing a reaction to a medication. That medication was administered on the 21st, and from the 21st, I would like to, all of you at some point, please, to look at, on the record here, page 9924, there's a beautiful chart we made of the platelets, and they drop precipitously.
Yeah, I see that, but your expert,
and therefore,
but again, your expert said that on the date of surgery, it was fine for them to go forward with the surgery.
that it was fine to go forward with, I'm sorry.
Yes.
So,
your
okay, the
expert
surgery,
said-
just so we're clear, We're not alleging anything with regards to the surgery. What we're alleging here is that there was a delay, not only on the 28th, but also on the 2nd of October. We also calculated the 4T calculation there. And throughout that entire period, until this was diagnosed finally, on the 7th, 8th, until it was diagnosed on those dates, there was a delay in diagnosing this severe and known allergy to a medication, heparin.
One thing, let's look at this. Let's take your base date for September 21st. I'm looking at your expert's affidavit.
Yes.
Platelets were 146. On September 28th, there's actually two amounts. I'm assuming one is I'm not assuming anything. I don't know whether one is as a result of a transfusion or one is a result of the surgery. In any event, we'll take the lower amount. If you take the lower amount from the higher amount, I do the math, and honestly, you're just a hair short of 30, which would give you the 1 point.
Okay, so first of all, that's true.
That's your
We still
dates.
have, and I want you to please recall that we have the calculation on the 28th. We also have the calculation on October 2nd as well.
And where is that in the expert's affidavit?
In the expert affidavit, I see
it would have to
the
be-
record of appeal.
That's where it would have to be.
It is in there, and he
Here, I'm
says, and it says
sorry.
the HIT score would have been 6, high probability of HIT, and I can pull up the affidavit.
Yeah, on the next paragraph, but he doesn't, it says was greater than 6, but he doesn't break it down. He doesn't say why. I mean, he does say it. It would have been 6. He just gives another point. Because they would notice, all right. I'm going to withdraw it. It's not really a question. I'm going to withdraw it. Let's hear from your adversary.
Okay. Thank you.
Good afternoon.
You can proceed. Oh, I'm sorry. God, it has been a long day for us all, right?
Yes.
Go ahead. Go ahead. Now you're going to be on the hot seat. Go ahead. Tell us who you are.
Good afternoon, Your Honors. Gregory Casino for the defendant's appellants in this case. It's our contention that the entire way that the plaintiff's expert calculated what the plaintiff's hit score would have been on different dates was completely speculative. This idea that the plaintiff's expert used the platelet level on September 21st, our experts gave great detail as to why you do not use that number. You don't use the 140.
They weren't that detailed, but they did provide a reason why.
Yes, their explanation is that, you know, there's surgical changes. The plaintiff underwent a significant heart surgery. There's going to be changes. There's going to be blood products used. There's going to be blood loss. And so that is why you use, and also there's a natural.
Right, but there was no blood loss between the 21st and the 28th, because there had been no surgery yet, right?
Correct.
So what do you make of your argument of your adversary that it's just common sense that if she's reacting to the medication, and that's apparently what was happening in terms of her platelets going down, that in terms of the looking at her platelets, you would look from the onset of when she was taking the medication until the point where it dropped to the 30% level, which would otherwise then start racking up points for the 4T.
Well, the administration of heparin is going to cause a reduction in blood platelet levels absent any sort of immune allergic response here. So that's the whole idea of the heparin, and is to prevent the clotting. It was necessary for the surgery. They stopped it after approximately 3 or 4 days. I think it was on the 23rd or the 24th. They didn't restart it again until the surgery. Heparin causes blood platelet count to go down, which is thrombocytopenia, but not all thrombocytopenia is, just because somebody has thrombocytopenia does not mean that they have heparin-induced thrombocytopenia. So that's really what the plaintiff's claim here is. So just showing, which is why there's this score, this hit score analysis that's been developed to figure out what the chances are and what the, when you should be looking for. This is, blood platelet, a decrease in blood platelet count that's caused by something, something more nefarious than just, just the heparin, which is basically the heparin doing its job. So I would submit that, just pointing to the decrease is simply not going to be enough, which is, what the plaintiff's expert is talking about. And the plaintiff's expert also refers to some issues with the fingertips.
Let me stop you on the first one, but that is one of the 4 factors, so of course he's got to talk about it.
Yes, of course.
He does talk about the other 3.
Yes.
Right. So why don't we have an issue of fact about whether that 4T criteria was met by September 28th?
Well, because, all right, there is all these other reasons why the plaintiff could have been experiencing these issues. The plaintiff had these global, she had global cardiopulmonary issues. Even then, obviously, post the surgery, she had undergone cardioversion. She was on vasoconstrictors. Those could cause all those other issues, obviously. We're talking about after the surgery here. But all that we have here is the plaintiff's, even if this court wants to, I know it's 29 and it's slightly under 30, even if you want to give the plaintiff 1 point for that, which I don't agree you should, the plaintiff's expert never actually explains, fine, you're aware of this. We were always aware that this was something, and that's why we were continuing to test this woman's, her platelet count throughout her admission there, because this is, something that we know can potentially happen anytime you give somebody heparin. The plaintiff's expert never actually identifies based on what actually would have happened once you have these scores. I mean, if you're talking about the lower level of concern, all it is means you're watching for it. And if you notice the plaintiff's platelet levels, a lot of PLs, actually went up right before, right before the surgery, and this she had a number, it was 122 right after the surgery.
But the heparin had been discontinued during that period of time, right?
Excuse me, Your Honor?
Had not the heparin been discontinued during that period of time?
It had, Your Honor. It had, Your Honor. So, I mean, that was another factor to consider.
But on the date of the surgery, she starts out at 103 and then it goes up to 122. She was given transfusions there then, wasn't she?
And she was also given heparin for the surgery itself. I mean, she's having valve replacements, you need to have heparin administered.
But when you say it went up on the 28th, there was a verifiable reason. The 103, if you look at it, brings her platelet count down from her date of admission until the surgery, right?
Yes.
And that's...
And again, even if you're looking at this beforehand, it's still this test. I mean, just because platelet counts go down and the patient has thrombocytopenia.
We agree with that.
Yes.
But you're not addressing the other criteria, which the plaintiff's expert went through, to say unless there's no facts that would otherwise support the conclusion on the rest of the criteria, then what you're talking about is only, it's not a summary judgment issue, it's an issue for the jury.
Well, Your Honor, as we pointed out, there were other potential causes for the ischemia in the fingertips. The plaintiff had indicated she actually was admitted with
Where does that figure into the 4T?
Excuse me, Your Honor?
And where does that figure into the 4T?
Well, one of the factors is no other cause of the thrombocytopenia of the ischemia, the thrombocytopenia. Hold on one second. This would be, yeah, that would be, the plaintiff was relying on the blue fingertips to say that there must have been some sort of thrombosis that was causing that. So this would indicate that there really was no thrombosis, that was not the cause of the blue fingertips. Again, she had global issues. She had these discolorations before. She had cyanosis of other areas of her body as well. So I would submit that still, puts it, you wouldn't get the credit, you wouldn't get the points for that. And even still, I mean, the plaintiff's expert doesn't ever explain what would have happened had the plaintiff been, had a certain number on that score, on that, HIT scoring test been assigned on a certain date. He just says, it's my opinion that had this test been run on such a date, the plaintiff would have got such and such a number. And then on this other date, which is post-surgery.
Well, it's part of that, it would have been diagnosed sooner. I don't know that there's much in the record one way or the other about what effect that would have had, but I don't know.
Well, our experts had actually, they stated in their affirmation that even if you had diagnosed it sooner, this is a condition that, you stop the heparin, but the heparin had already been stopped, you administer the agatropan. The agatropan doesn't always do what it's supposed to do. This is kind of so it's very possible that even if they had, administered the agatropan at some earlier date, which the plaintiff's expert has never actually identified the date where this should have been administered, that the same outcome very likely could have occurred. And the plaintiff's expert never addressed that. All that the plaintiff's expert gave is some sort of vague proximate cause analysis at the proximate cause statement, just basically stating that with vigilance and elevated degree of suspicion, the diagnosis could be confirmed while in the early phases of the condition, an alternative anticoagulation therapy started, resulting in reduction in morbidity and mortality. The plaintiff's expert never says when the agatropan should have been administered. I mean, and even if you have that, you're getting even prior to the surgery, he never says that there should have been some sort of diagnosis of this condition, only a higher suspicion of it. So he never connects the two with what he says that our people should have been seeing and what our doctors should have been seeing and what the treatment would have been and what the net effect of that would have been. So we would submit that his entire position, both on the evidence of departure and on proximate cause, are too speculative to create an issue of fact.
Thank you.
Thank you.
Okay. All right, we'll hear rebuttal.
How does your expert establish that if a different course of treatment had been followed, the outcome would have been different?
So what the appellant's expert explains in his affirmation is that individuals, and I quote, with suspected HIT require immediate discontinuation of all sources of heparin and administration of non-heparin anticoagulant. We talked about that. And with vigilance and elevated degree of suspicion, the diagnosis can be confirmed while still in the early phase of the condition, he explains. An appropriate alternative anticoagulation therapy is started, resulting in reduction of morbidity and mortality.
So when, according to your expert, should it have been diagnosed?
So he explains that on October 28th, 2015, and certainly by October 2nd, 2015, when her fingers were getting noticeably worse, the expert states that it was paramount to manage this type of patient and to be aware of the thrombocytopenia can represent an early warning sign mandating further workup to exclude HIT as a possible etiology. Now, we can look at how quickly that was done on October 8th, but too late in the process. And therefore, he explains that...
Even the test on October 8th took till October 14th to come back positively diagnosing her. So let's assume the 4T on 10/2 had otherwise indicated testing. There would have been no definitive answer to that test for another 6 days, maybe?
And as you know from the subsequent treatment, it was simply enough to stop the heparin that was being administered and administer argatroban. That is the intervention, and that can be done right away.
See, that's what I'm unclear about, because the heparin was discontinued on September 28th.
For the surgery, briefly, and then they continued it again.
And then permanently by 10/5, done. She was done with it before they diagnosed.
Correct.
Before they even had a suspicion or
No, when they had a suspicion already, right.
And then by the 8th, when they without the confirmed diagnosis.
You don't need the confirmation.
They treated her.
That's correct. You don't need the confirmation. That's very important. I will just point out that even as I'm sitting there listening to the argument here, we're going through the 4Ts, and if you notice, the arguments that are being made are, confusing both the ischemia and what's called the cyanosis to the fingers, the evidence of the thrombosis, and the thrombocytopenia, which are the platelets dropping. So we do, and I saw him standing here and trying to explain them and going through and actually confusing the two during the calculation that he's talking about of the 4Ts. I will read one thing that I think is the most important for us here, and that is the determination made by the judge here. I'm quoting from the decision. It was clear to me that the treating doctors considered HIT in a timely manner to do a differential diagnosis and treating various other conditions. The judge made an issue of fact, an improper issue of fact determination in this case. He took essentially the baseline issue that we've discussed previously and that you've discussed with counsel here, it was not rebutted by their expert. They did not discuss as to why I'm still completely confused, did not understand why it was that the date of administration of a medication which we're alleging is the medication causing the allergy, why that date would not be used. I have no idea why anyone would not use that date as the baseline, even if somebody does explain that, which they did not do. If somebody did explain that, there would still be an issue of fact, which is what we have here.
Okay, thank you. Thank you both. Thank you both for your patience in waiting for us today.
Aaron? Got it. Great. Great.